everybody online? Good. Right. Meeting of the Michigan Board of State Canvassers is convened and in order at 10 a.m. Good morning. Less than a full room today. We are going to begin with public comment. Give 5 minutes per comment, and we will start with Mr. Liedl.
Good morning, Chairman Hauskamp and members. 2 items I wanted to bring to the board's attention during public comment this morning. The first relates to the petition manuals that you'll consider later on your agenda today. And the second relates to our client Invest in My Kids and their proposed constitutional amendment. On the first, I'd like to applaud the Bureau for its work in preparing the manuals, particularly separating the manuals for use relating to petitions between petitions relating to candidates and petitions relating to ballot proposals. But do want to point out and encourage the board to correct these before the board makes the final adoption. 2 typographical errors in the manual. I'm not sure if those are still in the manual that's on the website or before you. I'm not sure if it was slipped out or not, but at least with the last version that I looked at, there are 2 typos in the manual relating to ballot questions and proposals. The first on page 18, section K, within the second paragraph of the text for the certificate of circulator, instead of a check mark, a letter U with an umlaut appears. The ballot question manual, page 18, section K, relating to the certificate of circulator. I think the intent is that there actually be an actual check marks, as is the case in the manual for nominating petitions, but instead it's a letter U with an umlaut above the U. I believe it should be a checkbox and encourage the board to change that before you approve. And then on page 8, section D, near the bottom of the page, within the body of an email address, Michigan is misspelled as Michigan, with G-I-A-N. So probably a good idea to correct that typo before the board approves it as well. But again, thank the Bureau for its excellent work in preparing updated manuals, and I recognize the difficulty in doing so given the uncertainties created by the unconstitutional act adopted by the legislature in 2018 that has been found unconstitutional by courts that make interpretation of the remaining statute a bit difficult. Second item relates to the Invest in My Kids proposal. I was not at your meeting on July 10th, but did have the opportunity to review the video of the meeting. And I did note that there was an awful lot of misinformation, speculation, and less than informed information provided by the board that the board appeared to act upon when it then proceeded to, without statutory authority, rescind a prior action of the board. There's nothing in the statute that authorizes the board to rescind a prior approval. And the board, as Michigan case law makes clear, only has the authority to engage in those acts specifically authorized by the legislature. The board had no more authority to rescind the approval of a petition summary than it does to rescind the certification of election results after they have been approved by the board. We want to raise that legal issue with you and point out that violation of law. Secondly, there seems to be some confusion about materials submitted by Invest in My Kids. We provided you a comprehensive summary by your deadline under your rules electronically on Wednesday and provided a courtesy paper copy today that clearly indicates, 1, Invest in My Kids submitted an original proposed constitutional amendment on June 4th, 2025. The Bureau of Elections proceeded as it normally does to notify the public of that submission and submit some deadlines to assist the director in preparing a 100-word summary. Prior to the deadline for comments, my client, Invest in My Kids, decided that they wanted to proceed with a different constitutional amendment. And on June 16th, as indicated at tab E in the materials submitted, Invest in My Kids withdrew the petition. We indicated in 3 different writings provided to the Bureau and the board through its process for submission that we were withdrawing the proposed constitutional amendment and petition submitted June 4th and requesting approval of a new petition. We urged the board to correct this issue because the deadline for the board to act on that information submitted on June 16th was July 16th. So the board has now missed its statutory deadline to either approve or reject if the board believes that it has rescinded a prior approval, that deadline. Happy to answer any questions about any of the materials or the issues that the board has created at its July 10th meeting.
Are there any questions from the board members?
I looked at your various submissions. So the first was on, your first submission was on June 4th,
Yes.
and then on June 16th, and then on June 25th.
Yep, June 25th was a submission not relating to the content of the constitutional amendment. It was only incorporating suggestions on the form of the petition.
Right, and as I recall, on the 27th, there was some confusion about the word public in local public schools.
Submission not relating to the content of the constitutional amendment. It was only incorporating suggestions on the form of the petition.
Right, and as I recall, on the 27th, there was some confusion about the word public in local public school districts. And your June 16th amended or revised petition excluded the word public.
That's correct, because there were 2 changes made to the proposed constitutional amendment in the new proposed constitutional amendment submitted on June 16th.
Right, you included a date and
Changed a reference to a date and changed the reference from local public school districts to local school districts. So from June 16th on, the only proposal before the board and the Bureau was a proposed constitutional amendment that referenced local school districts.
but your proposed summary included the word public.
Sure.
And it included the word public on June 25th.
No,
It did.
the petition, if I'm looking at the petition, if you look at tab E, if you look at the actual text of the petition,
No, I'm not talking about the text of the petition. I'm talking about your proposed summary.
well, the proposed summary is on the petition.
But the one on the petition is different than
Okay.
the one that you urged us to accept.
I didn't urge anyone to
Well-
accept
No?
on June 16th.
I mean, right, okay, you were suggesting language to modify the proposed summary
Right.
that was drafted by the deputy director. Right, and even on June 25th, you included the word public, although it had been
I
excluded.
don't think on June 25th there was anything submitted other than a petition.
No, I found in my file a letter dated June 25th.
I don't have a letter dated June 25th.
A.
I have a June 20th submission of the petition, and the only summary references local school districts.
So it was a memorandum on June 25th, which included.
Oh, the memorandum to the board in advance of its meeting?
Yes,
Yeah?
yes.
Okay.
Which included a proposed
Yes.
changes to the deputy director's
Mm-hmm.
summary. And again, it included the word public,
Right.
which you had previously excluded.
We were
So-
making comments on the director's proposed summary, which included the word local public school district. We're fine with the summary referencing local school districts as local public school districts. That's exactly what there are. There is no such thing in Michigan as a private school district. All local school districts in Michigan are local districts. The issue is not with the summary. The issue is what proposed constitutional amendment was before the board. And from June 16th on, the only proposed constitutional amendment before the board was the revised, new proposed constitutional amendment. We withdrew the prior submission.
Right.
Right.
And you deleted the word public, but you kept it in your proposed
No,
summary,
if you
which-
look on the petition itself, which includes a summary, there is no word in the summary that appears on the petition on June 16th. The word local, it says local school district.
Right.
I'm looking
No.
on the front page of the petition submitted on June 16th and the back page of the petition submitted June 16th. That was the proposed constitutional amendment before the board.
Right.
Local school district. And again, any summary is not relevant because it's a summary that's going to be changed. The question is, and the issues that were addressed on June 10th was some allegation that the proposed constitutional had somehow been changed, constitutional amendment had somehow been changed without notice to the Bureau and the board. That's simply not the case. We withdrew the June 4th proposal and submitted a proposal on June 16th, a new proposed constitutional amendment.
Right, I understand that. Yeah. I'm just suggesting that the change appeared to be material and that the material submitted by you to us did not reflect, your proposed summary did not reflect the change
Well,
you had made
again-
in the constitutional amendment.
On June 16th, at tab E, the second page after tab E, the summary of the petition is included in the petition on the front page. And it says, to support classrooms in local school districts. If you turn to the next page, the summary is reprinted. Local school districts. We do not have any issue if any summary prepared by the director uses local public school districts. We supported that language. That is not what's relevant for determining which proposed constitutional amendment is before the board. The constitutional amendment before the board after June 16th was a constitutional amendment that in the body of the constitutional amendment uses the phrase local school district.
So you deleted, just to be clear, you deleted in the June 16th revised petition, you deleted the word public, but you were perfectly happy, satisfied, I should say, to have that word included in the director's summary.
Sure.
Okay, that's all.
Yep. Again, and I want to note for the board, the statute is pretty clear. There were a lot of references to processes and procedures and legislative procedures that do not apply to the board. The statute imposes a duty on the board to approve or reject a summary of a proposed constitutional amendment submitted by someone within 30 days. That did occur on June 16th, and the board has not yet acted on that proposal. We now have a proposal from the director that purports to submit a deadline for approval or rejection by the Board of State Canvassers of August 9th. What submission triggered that deadline? 30 days before August 9th is July 10th. Invest in My Kids submitted nothing to the Board of State Canvassers on July 10th. I'm encouraging the board to consider its duties under the statute. You can see the plain language in the memorandum I'm submitting to you on the top of page 3 of the memorandum.
Mr. Lidl, we're out of time.
Okay.
You had time. You've made your statement. We appreciate your statement, but we need to move on.
All right, I thank you for your time. And I
Thank you,
urge
Chair.
the board to correct its noncompliance with the statute by acting today to affirmatively approve the previously approved statement and the form of the petition, which the Bureau has indicated has no issues.
Thank you for your time.
Thank you.
Mr. Doster. Same 5-minute rule applies.
Good morning, Mr. Chair, members of the board. Eric Doster on behalf of Small Business for a Better Michigan. And I would like to, from a public comment, address the comments you just heard and in the Invest in My Kids matter. Abraham Lincoln defined a hypocrite as, and I quote, "the man who murdered his parents and then pleaded for mercy on the grounds that he was an orphan," end of quote. In the present case, Invest in My Kids chose to withdraw its initial petition and now blames the Bureau of Elections and, by extension, this board for all of the events that resulted when Invest in My Kids voluntarily withdrew its June 4 petition on June 16. Quite simply, when a petition is withdrawn, the process stops. I have withdrawn numerous statewide petitions, all of which were before this board for final certification, which is well beyond where we are today, and the process stopped at that moment. Over the years, we have witnessed at these hearings petition sponsors appear before the board and withdraw their own petitions. They are well within their rights to do so and are always free to resubmit. In the present situation, when the initial petition was withdrawn by Invest in My Kids, the process stopped right then and there until the sponsor submits a new petition to start the process again. But in this case, the process did not initially start again after Invest in My Kids withdrew its petition. More to the point, Invest in My Kids knew that the process did not start again and knowingly perpetuated comments and took actions on the June 4th petition that they withdrew. The facts here speak for themselves. When Invest in My Kids filed its new petition on June 16th, why didn't they contact the Bureau of Elections that a new announcement with a new public comment period had not yet been issued? On June 23, when the deputy director submitted his draft petition language based on the June 4 petitions using the word local that was withdrawn, why did Invest in My Kids remain silent? On June 25, and as pointed out by Vice Chair Gurwitz, Invest in My Kids submitted a response to my public comments that were based on the June 4 petition that was withdrawn and of no further effect. Again, they remained silent, but their actions certainly misled us all to believe that the June 4 petition was still viable. And even on the day of the June 27 hearing, where this board was scheduled to adopt summary language regarding the June 4 petition that was withdrawn, Invest in My Kids remained silent when Mr. Fracassi was referring to his draft language at the meeting and again read the phrase, quote, "local public school district classrooms," close quotes, which applied only to the withdrawn petition. And now, according to the 72 pages filed with this board a little over 48 hours ago, which threatens this board with litigation, when Invest in My Kids is dripping with unclean hands for its actions in this matter, Invest in My Kids casts exclusive blame on the Bureau of Elections for actions entirely within the control of Invest in My Kids. Remember, since June 16th, Invest in My Kids has had the opportunity to request that a new announcement and a new public comment period be sent out regarding its June 16 proposal, but has chosen to remain silent despite multiple reminders that everyone else was wasting their time acting on a withdrawn petition. On July 10, this board took the only actions it had available to fix the situation created only by the actions and inactions of Invest in My Kids. The Bureau of Elections deserves better than the attacking comments submitted by Invest in My Kids. The public deserves better than to allow Invest in My Kids to engage in gamesmanship and then blame everyone else when the facts became known. Invest in My Kids, which withdrew its own petition, should not be allowed to receive any form of mercy from this board. And I appreciate the opportunity to provide public comments to this board.
Thank you. Is there, board members, anybody want a question? No?
Thank you.
Mr. Dosser, thank you. Before we move on from the public comment, based on what we've listened to, I would like to ask the acting director, can you just for the sake of the record provide a timeline from the Bureau standpoint?
Sure. Bear with me because there's a lot with the timeline, so I'll kind of like walk through from start to finish the back and forth that we've had. So it starts first on June 4th, pulling up dates. So it starts forth on June 4th, 2025, which is when the sponsor submitted the petition. Between June 4th and June 10th, which is the next date relevant, is when we are contacting, trying to determine a date for an appropriate board meeting to hear the petition language. So that's why there's a little bit of a gap between June 4th and June 10th. On June 10th, 2025, the Bureau posted the announcement requesting public comment. This is something we routinely do for both public comment for summary language purposes as well as ballot language purposes. We post and we solicit any information that may be helpful that we can use to make a recommendation to the board to draft. We typically leave that open for 5 business days. That public comment period closed on June 17th. On June 16th, we received an email, the Bureau received an email where the sponsor withdrew the petition using the words, we withdraw the petition, and resubmitted a version. In that version, the word public was removed, and the impact of the withdrawal was missed by Bureau staff. That same day, I believe it was about 10 minutes later, an additional version was submitted to us. A second email was submitted saying that this email superseded the prior email, and the additional petition was submitted. And at this point, so this is both on June 16th, staff was unaware of the change in the language on the back of the petition, removing the word public. Again, for the reasons that I've outlined before, staff's approval as to form review does not get into the substance of the petition. The board's approval does not go to the substance of the petition, as you're well aware. On June 23rd, 2025, the meeting agenda for the June 27th meeting was posted. The meeting agenda did contain my draft 100-word summary of purpose. And then on June 25th, 2025, we received a memo that was provided as part of the board materials that was in response to the meeting materials. And that's the memo that Vice Chair Gurwitz was just referencing. Then we had the board meeting on June 27th, as we're aware. And then on July 2nd, the petition was submitted. There were 3 changes that were made to the petition on July 2nd, and I'm going to just read what was exactly, I'm just going to read verbatim what was provided to us from the sponsors. So the first change incorporates the petition summary as approved by the Board of State Canvassers at the June 27th meeting. And then the second change, quote, replaces the it edits the sentence immediately following the petition summary on the front side of the revised petition to ensure greater consistency with the text of MCL 168.482. The second change replaces, quote, "for the full text of proposed amendments to Section 7 and 11 of Article 9 of the state constitution, along with the provisions of the existing constitution that would be altered or abrogated if the proposal is adopted. See the reverse side of this petition," end quote, with, quote, "for the full text of proposed Section 7 and 11 of Article 9 of the state constitution, see the reverse side of this petition. Provisions of existing constitution altered or abrogated by the proposal if adopted, colon, Sections 1, 7, and 11 of Article 9. And then the third change that was made was to add a QR code at the bottom of the petition for a unique tracking that sponsors put on the petition. So the July 2nd, just to kind of summarize that a little bit cleaner, the July 2nd filing had 3 changes. It replaced the summary language from the June 27th meeting. It added the QR code at the bottom of the petition, and it changed one of the instructional pieces under the summary language for the form of the petition itself. Then on July 10th, we had an additional board meeting. We had received prior to that a letter from Charlie Spies that the board received at the last meeting in their packet. I don't remember the date of that off the top of my head. Basically bringing some of these changes and indicating some of these, as we heard last meeting as well. At the July 10th meeting, the board rescinded approval of the summary language, and in its motion, the board asked the Bureau to start the process over, the approval process over, which includes posting a new summary, or posting the petition, soliciting public comments to draft a new summary. And in the motion, the board said to accept it as a new filing date of July 10th, which was the date of that meeting. On July 14th, which was the next business day, Bureau posted the July 2nd version of the petition. And the reason we did that is because, again, that instructional line had changed. So we posted the July 2nd version on our website to as part of its announcement to solicit public comment. And that public comment period closes on July 21st, which is this coming Monday. And we are planning, in the announcement, we didn't have a date finalized. We do now. We are planning on taking that up at the July 31st meeting. Which will be noticed after the conclusion of this meeting. I generally don't like to put a notice out the same week of a meeting because people have in the past not shown up thinking that the meeting got changed. So we tend to wait for public, just so public is aware and there's no confusion. So the 30-day requirement under 482B is the board has 30 days to approve or reject. Considering that the most recent version that we've received, the version that is posted now, was July 2nd, 30 days from that is August 1st. If we go by the date in the board's motion, which was considering it received July 10th, that does run August 9th. And like I said, we do have a board meeting scheduled on July 31st. So that's a timeline that I have from what I've been able to gather between the emails and that we've received and the letters and everything. So happy to take any questions if there are any.
Does the board members have any questions for Acting Director Francesa?
One quick. Can you tell me the last 2 dates you mentioned? The 30 days that it ran from?
Yes. So 30 days from July 2nd is August 1st.
Okay.
And then 30 days from July 10th is August 9th.
Okay, thank you.
Vice Chair, have you any questions?
No.
Mr. Cordes? No. There are no questions. Mr. Leal, I'm only going to ask one, I only need an answer to one question. When you spoke in your public comment, you mentioned that you were surprised and confused that there is a petition that is up for public comment, and it's being considered on July 31st. Are you saying you do not want that? Are you withdrawing that petition, or are you aware of what? That's the only issue I really want you to address.
I won't address any further issues. No, Mr. Chair. I am saying that the board has pending before it a request for approval of a petition summary that was included in a letter received by the Bureau on June 16th, and it says, quote, in connection with this new filing, we request pursuant to MCL 168.482B that the Board of State Canvassers approve the content of the summary of the purpose of this petition. No subsequent submissions requested approval. There is no 30-day deadline or process for the form of a petition.
We're not going down that road. This is a really simple one. I'm asking you a question.
Yeah.
You raised an issue about a petition that is in front of the board right now, or that will be in front of the board for considered. It's open for public comment right now. That's your petition. You heard what happened here on the 10th. Do you want that petition to continue? Do you want the public comment to stay open until the 21st? And do you want us to consider that on the 31st?
Yes, we
Okay.
continue to ask the board to approve our request.
That was a yes or a
for
no
approval
question.
as the form of the June
You want to
16th
continue,
petition summary.
you want to continue the public comment, and you want to come back here on the 31st and work through your petition.
Our request for approval of a petition summary remains unchanged. Yes, we would like you to do it today.
No, we
Given
won't
the
do it
deadline.
today. We have a petition that is out. Public comment doesn't end until Monday night. We will be back here on the 31st, and thank you for your comments.
Thank you.
Okay, before we move on, I have one technical one I have to bring up here. I've noticed on the vice chair's laptop that she's getting a low battery light. That could be a problem. Was that it? Beautiful.
That's an easy, I'm happy to help with that.
You're not billing us for tech time, right? Okay. Thank you very much. Moving along, item number 2, consideration of the minutes for the July 10th, 2025 meeting. Do I have a motion?
So moved.
You're moved. Go ahead, second.
Second.
All in favor?
Aye.
Aye. Motion passes. Item number 3, we have a consideration of the sufficiency of the recall petition submitted by Keith Butkovich against Peter Herzberg. Reasons for the recall printed on the petition are as follows. Voting against House Bill 4170, this bill reduces the state personal income tax rate from 4.25% to 4.05%. I have no one's here speaking on. There we go. Mr. Bukovich, will you state your name and spell it for the recorder?
Sure. Keith Butkovich, Keith, Butkovich.
Sir, you have 5 minutes.
Yes, this is recall petition against my state rep of District 25, Peter Herzberg. There was a House bill to lower the income tax rate, as it states here, from 4.25% to 4.05%. And the representative voted against that. And for that reason, that is an action in office. That is a factual statement. And I am wishing to circulate recall petitions for that reason.
Okay. Do we have any questions from the board?
I have a question. Do you have roll call from the meeting or anything that verifies that he voted no?
I don't have the roll call on me, but on the official vote tally, it says he voted against.
Okay. Thank you.
The wording is pretty straightforward. Vice Chair, any comments?
Yes, I looked at what we had done with regard to a number of similar motions earlier, where the reason for recall simply referred to the vote on a particular bill. We held that that was not sufficiently clear, but where the reason did say where the proposed language in the recall petition did indicate what the bill did and accurately indicated what the substance of the bill was, we, in a number of occasions, voted that it was sufficiently clear. And I think that this appears to be sufficiently clear, and that approving the reason for recall would be consistent with what we had done in the past.
No, I agree with you. I think it's, this is truly one of those, the less said, the less amended. Yeah.
Yeah.
Mr. Cordes?
No, only that I went through and I read the bill. It's, I mean, everything on there is pretty straightforward. I read the bill. I did confirm the no vote, so looks factual to me.
I would entertain a motion.
I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Keith
Butkovich.
Butkovich,
Okay.
thank you, against State Representative Peter Hertzberg on July 8, 2025 are factual and sufficiently clear because they state the name of the bill and the purpose of the bill.
Second.
All in favor?
Aye.
Aye.
Motion passes.
Thank you.
Thank you, sir. Item number 4 on the agenda this morning, we have a discussion of the investigation into the qualifying petitions submitted by Cornell West. And I would ask the acting director to walk us into that one.
Sure. So as you may recall, this stems back to qualifying petitions, that were submitted by Cornell West for the 2024 election. The board did receive a complaint against the specific circulators, against a group of circulators, I should say, alleging, raising allegations of fraud in these specific circulators, raising allegations that the signatures didn't match, et cetera. So there's a little bit of legal action as well. It eventually came back to the board and we commenced an investigation. So the board asked, after that, the board asked staff to, or through the Attorney General, I should say, the Attorney General's office, to reach out to counsel for Mr. West and ask for exemplars of signatures from the out-of-state circulators. Specifically, one of the problems that as you may recall, that we had with it was we can verify signatures in the qualified voter file for Michigan residents. If individuals are not registered to vote in Michigan, whether it's because they live in Michigan and are not registered, or that they do not reside in Michigan, we don't have a way of gathering those, an exemplar to match the signature. So we did request an exemplar and were provided with some at first, not all of them. And then the board voted to send a subpoena to Cornell West, again through the attorney, asking for the remaining ones. We have gotten at this point exemplars from almost all of them. There are a couple that we have not received. I'm trying to find the number quickly, but I'm not. 5, that's what I thought. Okay, there it is. There are 5 that we have not been able to obtain signature exemplars on to be able to verify one way or the other. So staff reviewed the signatures that were provided, compared them to the petition's signature, and then compared it to the signatures exemplar that was provided. They all came, the exemplars all came in the form of a driver's license. And so staff had gone through and matched the signature versus the petition. It's not in your packet, but you've got a hard copy of it, which we went through the petitions and just took screenshots of every circulator who was part of the complaint and the signatures that we reviewed. So you can see just the signatures compared against themselves, nothing else, just the signatures against themselves. And then we do have in your packets as well the digital version of the driver's license signatures if you want to compare at all. Staff had gone through and we reviewed the signatures, and long story short, we did determine that for 28 of the 29 circulators that we were provided with exemplars, it did not appear that there was any circulator fraud that had taken place. The signatures overall matched the driver's license signature exemplar that we were provided, or they matched the signature that was contained in the qualified voter file using the same standards that we use on petitions for voters. With one circulator, with one circulator, we determined that the signature on the petition did not sufficiently agree with the signature on the driver's license that was provided to us. At this point, so I'm gonna back up with as to the 28 of the 29 circulators. At this point, we would recommend in the staff report we recommend that the investigation be concluded. There's no evidence to us that there was any widespread fraud or that the signatures otherwise do not sufficiently agree with what was provided to us. With this remaining one, under Michigan election law, an individual shall not sign a name as circulator other than their own, is what the specific statutory text says. Staff is unable at this point to determine whether or not this is fraud or if this is an individual whose driver's license signature is outdated. We don't have any information on that. In order to obtain information on that, we did attempt several times to get a hold of the specific circulator. We worked with our Office of Investigative Services, which is an internal division within the Department of State that we have coordinated with before on signature issues specifically related to petitions. As at least as Member Gurwitz may recall, in 22 when we had the allegations of signatures that did not sufficiently agree, we coordinated with the Office of Investigative Services to investigate those further. We did the same thing here with this one individual circulator. We reached out to OIS and asked them to attempt to make contact with him. Long story short, they were unsuccessful. They attempted to call, they attempted to mail, physically mail something, as well as try to get a hold in any way, and the individuals were not able to reach the circulator. So at this point, staff is left with signatures from this individual that do not match the driver's license. And we have no way to determine anything beyond that as of right now, but we are confident to say that they do not sufficiently agree. So from there, what election law says is the board's options. If the board determines that a violation of the election law has occurred in this context, meaning that if the board determines that this is a fraudulent signature, that this was a fraudulent signature, the board has 5 options under election law. It can impose an administrative fine of not more than $5,000 on the organization or person sponsoring the petition drive. It can assess the cost of canvassing the petitions on the organization or person sponsoring the petition drive. It can disqualify the circulator from circulating for not more than 4 years. It can disqualify the obviously fraudulent signature on the petition drive, or it can disqualify the candidate. What the Court of Appeals said as part of this litigation was that this investigation does not have to occur prior to the certification deadline because there are those other options. So an investigation has to commence, but in the opinion that the Court of Appeals issued is that the purpose of this investigation doesn't have to necessarily be solely for determining ballot access. It can also be for any one of those other 4 issues, for banning circulator or assessing a fine, et cetera. So those are the options that are under election law. I will note that even with this, it would not have affected the ballot status of Mr. West in the November 2024, even with this one circulator, if the sample was determined to if this circulator signature was determined not to have matched in the sample, it would not have affected our calculations for Cornell West. So that's a kind of high level. I'm happy to answer any further questions.
Question about, so we have, after all the investigation, we're down to one single individual, and that still has some cloud on it. But the question is, how many petitions sheets did that one individual? You know, I should have that answer. I apologize, but Mr. Brewer has that answer.
I can. If you,
Please come up. Your mic, there you go. Now it's on.
Sorry?
No, your mic delayed there. We're having technical issues this morning.
Seems to be on. I have the red light.
you're good now.
There you
Okay.
go.
All right, thank you. Good morning, members of the board. My name is Mark Brewer of Goodman Acker on behalf of Challenger Rosa Holiday. In this matter, we brought the original challenge not only to circulators but to signatures. I want to thank the board, the staff, the Attorney General for its persistence in pursuing this investigation pursuant to the court's order. I think it's very important, though, that just as petition circulator fraud should have consequences, disqualification of signatures and prosecution, as we see still going on dating back to 1982, forged circulator signatures should also be penalized. Mr. Delahunt appears as circulator on sheets with 896 signatures. He was one of the most prolific circulators, and I put that in quotes, for the West campaign. Nearly 1,000 signatures appear on petition sheets in which his signature as circulator is forged. So I think it's very important for this board to send a message that circulator fraud of any scale is intolerable. And I know later on in the agenda you've got a procedure going forward, and I have more remarks about that. But in this particular case, I would urge the board to fine the West campaign, to charge them with the cost of your investigation, which yielded nearly 1,000 invalid signatures. I understand the conclusion of the staff that it would not have affected the result, but breaking the law and circulator forgery is intolerable, and the board needs to send a message that it will not tolerate it whenever it's discovered. So I'd urge you to take some punitive action against the West campaign based on Mr. Delahunt's forgeries.
Thank you for your comments, sir. Does the board, thank you for your summary as well, Mr. Fracassi. Does the board have any questions for the acting director? Any questions about process, procedure? Ms.
You
Cummings,
have-
there you go. I'm sorry.
So one of the things that we could do is charge the campaign for the cost of the canvas, or for the cost of the examination of these. Have you calculated what that cost could be?
I think we can, but I don't have an exact number to say right now what the cost would be.
we could also impose a fine of $5,000. That is within our authority.
As I read the statute, yes.
I agree with Mr. Brewer that this is a huge issue. And this was a campaign that was where a lot of out-of-state circulators were brought in to solicit signatures to get this independent candidate on the ballot for president. It appeared to have been conducted in a pretty hasty and, I would say, unlawful manner in a number of respects. I'm looking here at the signature comparisons that you provided us, and certainly with regard to this one circulator, there were a significant number of petition sheets that were signed with a name that did not match that of the circulator. So other people, and it's not just one person who was doing it. What it appears is that there were a number of people who were signing the name of this particular person. And so it's not just one person who has violated the statute, but a number of people who are violating the statute by signing the name of a circulator other than their own. So this is it appears to be fairly widespread. So, and I'm also, I'm just looking at these for the first time. I don't necessarily agree with the staff's conclusion that some of these other signatures sufficiently match. But apart from that, I think it is important for us to send a message out, and maybe to the West campaign, which was a hurried campaign. It came and went. But I think we need to send a message to everybody who is going to be submitting signatures for us to canvass in the next couple of years. We need to say that we take this very seriously and that we expect both circulators and the candidates to ensure that signatures are valid, because it is our responsibility to determine, with regard to any of the petitions that are submitted to us, that those petitions are supported by a sufficient number of valid signatures. So I think that for us to impose a fine is the reasonable thing to do with regard to the West campaign, but also sending a message to campaigns in the future, whether for candidates or ballot questions.
Thank you. I have a couple questions. One, to go back to, for all of the signatures that were challenged. Granted, we've had a couple, we can't get any detail on the individual. And I don't want to comment on that because that can happen. But we have one individual, and that one individual, we're pretty certain that those signatures were forged.
So what I can say is that in total, we had, what our review concluded was that there were 18 signatures from the circulators that we concluded did not match. With the, I should have said this at the beginning just to kind of preface, we looked at the sheets that were in the sample only. Just because that's, we pull the sample, the challenge is against the sample only. So I just wanted to clarify that one point. So out of the challenge, we determined that 18 did not sufficiently agree. From just this circulator. Thank you. Thank you for the clarification. From this. So out of Mr. Dillahunt's, he was on 13 sheets.
In the sample.
In the sample, yes, and in the complaint. And we've concluded that not one of them matched the exemplar provided. And it's, as always, our standards when we're using to determine a match, we resolve things in light of the individual. So, for example, with a voter, we take into consideration that voters might be signing on a clipboard exposed to elements, for example. So we use this exact same standard to match the version that you have in front of you to the version on the license that was provided. And I do have a copy of it up if anybody on the board would like to see it. I can't provide it to the public because it is a driver's license. That would violate federal law. But what I can say is it is nowhere near. It is night and day different.
Obviously.
Yes. We did again have the Office of Investigative Services look at it as well, just again, because that's kind of our normal practice. And this is in the staff report, but I will read a quote what they said. They said, the differences include a clear first and last name separated by a break in the writing contained in the signature on the petitions. The characteristic is not consistent with the single signature on the driver's license. And it was also observed that the circulator petitions clear letters can be made out, easily indicating almost all of the first and last name, and that is not the case with the driver's license signature either. So what I can say right now is that, at least for this one individual, the signatures do not sufficiently agree at all.
And it seems it's obvious that the campaign understood that, and for whatever reason, they filled his signature in. Whatever reason he had for not signing, it's a moot point. I agree totally with Vice Chair Gurwitz that we've argued this in this room. All of the people that are here have been in these conversations through the last couple campaigns. Matter of fact, we've had conversations about doing things like getting the legislature to talk about requirements for signature gathering companies. We've had a lot of those conversations. So I totally agree that this is something that we can't just kick it aside and not take a stance. But I do have one suggestion for the board to think of. We have an option. We have 5 different things we can do here, but we don't have a number for what the estimate of the cost of the canvas is, the investigation. And so what I would ask for is, could we get that as a number, and could we make a decision then based on what action we want to take after we have that number? Or
I think we could put together an estimate and present it at the next meeting if the board would like.
is that gives us the ability to look at that number versus, because we're going to have to figure out what the fine is anyway, right?
Right.
You're counting our time in this estimate, right? I'm teasing.
Our time is cheap.
Our time is cheap, yes.
That's a different issue.
So if we could as kind of an action step on item 4 here is we're not putting it aside, but we're asking if you would come back with an estimate, and then is it possible maybe to add that? Can you do that by the 31st?
Yeah, I think we can prepare that by the 31st for the board's meeting on the 31st.
I have an additional question, though. I don't think that all of these were not all challenged signatures, is that correct?
Those were all that were challenged as part of the circulator complaint, yes.
So some of these, you indicate that, okay, so Mr. Delahunt is not the only one where there were non-matching signatures.
That's correct.
Right. So I just think that there are others as well. So why are we focusing only on him?
So the main reason, there are others that did not match, but there were, with those circulators, there were some that did match. So in total, we determined that 27 did not sufficiently agree. 27 signatures did not sufficiently agree with this exemplar that was provided. Mr. Delahunt was the only one, it was the only circulator where there was not a single signature that we determined sufficiently agreed.
Okay, but there were certainly others where the names, the circulator name was in different and non-agreed handwriting, right? So, which suggests that the fraud was more widespread than just with regard to one circulator. that people were just taking a circulator's name and writing it, and without a whole lot of effort to duplicate what the handwriting should have been. So I just think that it's important to clearly indicate that he was not the only circulator, or that there were other people who signed the circulators when in fact they were signing a name other than their own.
So I just one thing I want to clarify with that part of it. So what you're getting at with the other circulators. So in general, there were other exemplars that were, in the exemplars, the signatures match. I'm going to start over because I feel like I'm not making any sense whatsoever. So with the circulators that we investigated and that we looked at, the signatures, there were some that matched, there were some that did not match. With what you're speaking about, I think would get to the issue as to whether or not you want to determine that the individual circulator was not is not eligible to circulate for a period of 4 years going forward. So this is, I will say, I will back up, I'm not aware of a time when the board has had this type of complaint. I'm kind of looking at Mr. Brewer to correct me if I'm wrong. I'm not aware of a time, let me rephrase that. I'm not aware of a time where the board has taken this type of action. That's part of why we're going to recommend the process that we go over as well. So as far as that end, those 5 options go, I think what Vice Chair Gerwitz, what you're talking about would go more to if the board were to take a decision to say that these individuals should not be allowed to circulate because the board has concluded that these signatures were fraud. That's how that would relate in. The statute does require a finding that the signatures were fraudulent, essentially. I use that term not as a term of art, but as a term of the board reviewing signatures, not the legal standard, to be clear. So that's just the one clarification I wanted to make on my end, because I don't think I was being as clear.
Are you are convinced that in the case of one circulator, that standard has been met, probably exceeded, right?
I can tell you at minimum in the case of one circulator, using the exact same standards that we applied in 2022, we would conclude that these do not sufficiently agree, and they are signatures of dubious authenticity.
So one of the things, if you have an exemplar from Mr. Delahunt.
Yes.
And there are many other signatures many other petitions which have been signed with that name, but they were not signed by Mr. Delahunt. They were signed by other people using Mr. Delahunt's name, right? That's what happens. Yeah. So some other circulators are signing using his name. So there are perhaps a significant number of circulators who are violating the law. You don't actually necessarily know that it's Mr. Delahunt. It's all these other people who are using his name, right?
I don't know. Yeah, I think that's correct. I don't know sitting here whether this was signed by a third person pretending to be this individual, and I don't know if Mr. Delahunt did sign it himself and it doesn't match. That's why we tried to reach out, tried to get information.
Okay, but I'm just looking at another person on what you have given us. Siobhan Johnson. So we have
What number?
number 15.
Thank you.
So it's pretty clear to me, and it was clear to the people doing the examination, that name was used as circulator on a number of petitions, and that it didn't match the exemplar which was given to us. So my point is, you don't necessarily know who the forger is.
I agree with that, yes.
So it is somewhat difficult to say, okay, this circulator is barred.
Thank you.
So that is a penalty which would be very difficult to impose. But I think that the response, and certainly we want responsible circulators, but we want responsible candidates and responsible ballot question committees. So where it is somewhat difficult to identify who has perpetrated the fraud, I think that we need to hold the campaign responsible. I wouldn't try to figure out, I have no idea who these people are.
Let's do this. Let's get an estimate of the numbers. And if there's room on the 31st, if you've got it by then, if you don't have it by then, put it on August, but I would say if you got it on the 31st, and then we can come back and at least calculate something. Is that fair?
Good idea.
Perfect. Outstanding. Consensus. Moving along to item number 5. And I would tell you right away, item number 5 and number 6, before we go down this road, today there is a single manual. It's all been approved, it's all been discussed, it's out there, it's being used. Item number 5 and number 6 represent taking that manual and turning it into 2 manuals. And so we've got folks that would like to talk to both item number 5 and number 6. But I think we can kind of combine some conversations here maybe. But I would ask the acting director to introduce the conversation for 5 and 6.
Absolutely. So this is, like you said, this is an update to our petition manuals in general. We put this before the board usually at the beginning of the cycle, just so that way we can have guides for candidates and for circulators as they are circulating petitions. We usually keep track. We pay attention to what, especially when we have the candidate certification meetings, the issues that we hear. We keep kind of note of what people are saying to us. These manuals are designed to help the public. It's designed to help candidates. It's designed to help circulators. So when we hear things that maybe are a little bit unclear or something like that, we try to respond and especially clarify some of those things. One of the things that we heard last cycle, I think the most, was the combination of putting them together. I think we heard it both from testimony from individuals, but we also heard it from candidates in the sense where they were saying they were following one part of the manual, but that was a part that applied to ballot questions and not to candidates, or vice versa. So the biggest change that we have done, our recommendation is to break those back up and have one manual that's focused on nominating petitions for partisan offices, and then have one manual that's focused on ballot question committees and the statewide ballot questions, so constitutional amendments, initiatives, and referendums. There is obviously overlap between the two. The methodology behind how we sample, the methodology on how we determine whether a signature sufficiently agrees, that applies to all petitions. But importantly, what we're doing with these is we are not making recommendations to the board at this point to substantively change process or change any of those things. The changes that the manuals have are that we have before you are, I would say, more technical in the sense that it clarifies some language. It clarifies some of the pieces that we've heard, just to provide some of those, some of that necessary clarification. We did post this several weeks ago on our website. We sent it out to our subscribers list and asked for public comment on it to see if there were additional points that the public didn't either understand or want to change, just so that way we can at least discuss it, or even if it is something that we can't change, we're able to say, well, this is a legal requirement, for example. So we did receive 2 public comments. One of the public comments that we received was inquiring about whether we would do the same thing for a judicial manual. The short answer to that is yes. We are looking into ways that we can kind of take this and make it clearer for judicial candidates. So that's why it's broken out into nominating petitions for partisan state offices and federal offices. Judicial candidates use a nonpartisan nominating petition, there are different elements that are on the nonpartisan that are not on the partisan. For example, party affiliation, the easy one, right? So we are trying to separate that to make that a little bit clearer as well, specifically with the heading elements. As you board is aware, they are very stringent. So we are working on separating the judicial piece out from the partisan, which is then also separate from the ballot question petitions as well. So that is coming. And then the next, sorry, I accidentally closed it. I'm trying to pull it back up real quick. The next public comment that we received was from Mark Grebner. Mr. Grebner did submit 4 numerical items of things that he would like to change, and that is also, it's also in your packet as well. So I'll kind of run through those briefly. So the first, Mr. Grebner had requested early access to the scanned petitions. So how it works with the petitions and the challenge period, how it all plays together. So I'll kind of talk about that briefly because I think that's necessary for this. For candidates, the challenge period is established in statute. It is a flat 7 days following the filing deadline, unless the petitions were not made available and the board by motion extends the deadline. So as you might recall from 2024, and with the adoption of random sampling for statewide candidates, we struggle to get that done in 7 days, especially if it comes on the date of the filing deadline. And the board did vote in 24 to extend that to be 7 days from the date we released the sample for the sampled candidates. For ballot questions, by virtue of a board vote, the challenge period is 10 business days. That is a board policy for a variety of reasons. We had discussed several years ago about whether to change that or not. At this time, we're not recommending changes because it's a very tight window with that. So Mr. Grebner had indicated in his comment about being able to still access the entire universe of the petition filing. We do make the entire universe available at the time we release the sample. And so we will release for candidate X, who is running for state senate next year, we will release the sample and say it's available for anybody to purchase it like we normally do. And at the same time, they also can request the entire filing for that candidate. We will have it available for folks to get the entire filing as well. The second comment was dealing with subsequent
Can I ask?
Sorry, yes, please, interrupt me at any
about
point.
that? So one of the things that Mr. Grebner is focusing on is the ability to identify duplicates.
Mm-hmm.
And so if you release the sample with regard to one candidate, are all of the samples released at the same time? Or are all of the scanned documents available at the same time? I'm trying to clarify for myself.
So I'll take kind of sampled candidates separate from non-sampled candidates. For non-sampled candidates, we generally do turn around those copy requests within 24 hours because of that tight turnaround with the 7-day window. We scan them and we try to turn it around within the copy request within 24 hours from when someone makes it available to us. For sampled candidates, I believe in 24 released them all at the same time, all the samples at the same time. And that's largely because I think they were just all available at the same time just because of the work that goes into it. So they were all made available at the same time, and then the challenge deadline was extended for that reason for the 7 days from when we released it. I don't know if that answers your question completely or not.
I'm not sure either. No, I'm just trying to figure out if what he's asking for is the ability to compare across not just the sample, but across the whole universe of signatures, to be able to identify duplicates. Is the procedure that we have sufficient for that, or is his suggestion one that we should entertain?
I personally believe it's sufficient. I think, and I did speak with him this morning. I was curious if he was going, I don't see him in the audience, but I did speak with him this morning via email, and it seemed like it was okay. I certainly do not want to misspeak or speak on his behalf at all. But I think by virtue of us making the universe available at the same time we make the sample available, in addition to if you're looking to other candidates that are not, that are in that universe as well, those are made available at the same time as well. So I think that resolves his, the concern that he raised.
So, I'm just looking back to 2022, when we had 10 Republican candidates for governor. And so the ability to look at all 10 submissions to identify duplicates is one that Mr. Grebner is highlighting, and, one that, next time we'll probably have 20, right? We're going to have a lot of work, and we want to give the public the information they need to do the job that they're doing. So it sounds like we have it.
Yeah, I think so. I think in '24, we had this with U.S. Senate candidates, right? So we again did sample, and it's the same thing. They're made available, and I think that's partly, if I'm remembering correctly, I think that's also partly why we released the samples at the same time, was so that way everything related was available at the same time. Okay. Because and this kind of relates to number 2 as well with his public comment. What election law requires is that you're only allowed to sign a petition for the number of people to be elected, meaning that if you're only nominating one person, then you're only allowed to sign one petition. So like for U.S. Senate, for governor, for these races that we're sampling, you're allowed to sign one petition for your respective candidate. You can't sign 2. If you sign 2, we invalidate. We invalidate the later signature. The first dated one is accepted, unless that first dated one has a different issue. If they if they put their birth date, something like that. So that's the that is kind of what Mr. Grebner and several folks want to be able to look at and compare for that. So that is how we do it with that, and that's different from. I want to just make sure I'm being clear with my point. It's different from judges. If you are electing more than one, you're allowed to sign more than one. So a lot of judicial offices will have 2 people. You're allowed to sign 2 petitions then. But once you go over, that's when that process kicks in. And that's his second point that he raises in his public comment. Do agree with him. We did, I think, make it, we accepted that change, and I think made it clearer in our manual, so. You're locked out. Did I want me to go? Okay, I didn't want to, if there were still questions. Okay. I think that kind of addresses number 2 as well. So number 3 in the comment was for rolling publication. This is something we heard before. And unfortunately, this is just not something that we administratively can do. What the request is that basically as we scan that we would just make them available on a rolling basis. Our hesitation with doing that is just the burden that is involved with it. This is already a very short time frame that's involved. So it's difficult for us to make spots available and to make petition sections available on a rolling basis. But what I will say is that we did purchase high-speed scanners. By also shifting the Bates numbering process to digital versus hand stamping, though that has dramatically decreased processing time, so we are able to turn them around pretty quickly, turn around those copy requests pretty quickly. So that is we did not accept that recommendation only because that's just not something that I think at this time we're able to do.
Is that something that, as you're working with the high-speed scanners in another campaign, that are kind of in a real full cycle coming up, also working with sampling, working with a lot of new things. Is it possible that maybe in the future we can revisit number 3 with the rolling based on procedures and and process optimizations that you discover.
Absolutely,
Or-
yeah. Yes, and that's partly why we come back to, and we try to do this every cycle, is for that exact reason. We're able to, sometimes we're able to say, hey, this is a thing that we can tighten up, or maybe this is an expansion we're able to make. At this point, I'm not comfortable with that, only because this is still this is only the second time we've done this process. So yes, I think this is something we can circle back to if we're able to accommodate it in a way that is okay for everybody, to be honest, so.
Well, and just to be fair, we've had so many conversations over the years about technology and other things. You know, one of the things that I think is still a spot on the wall that we talked about in our roundtable is the idea that you're not very many cycles away, maybe this cycle, where you can actually scan it and the software can break the information apart as well as create a PDF and possibly even provide some deduping on an automated basis that was available by report. So it seems like you're going to have a lot more changes this time.
It wouldn't surprise me. We might be having a completely different discussion 2 years from now. All right, so the last comment that, from Mr. Grebner at least, was permitting controlled pre-submission sheet numbering. This is one, there's no change in our process with this, but I think that we need to be a little bit clearer in the manual. And I will say that I do think that this also needs to be further refined, because based on the email that I got from him this morning, I think that something still in our manual isn't clear with this. So in general, when it comes to unique identifiers, we do not prohibit unique identifiers. So a unique identifier being like a barcode at the bottom of the sheet, or QR code, something like that. What our request always with the unique identifiers with this is, number one, no stickers. Stickers come off, they jam our machines, it's very difficult when we get stickers. And number two, the problem with stickers is that they're often covering up mandatory elements, which invalidates the entire sheet. So we have had drives that have had significant numbers of sheets just completely eliminated because the sticker, the barcode sticker, was placed over the circulator warning or something like that on the sheet. That invalidates the entire thing, because we don't know when that sticker was applied, so we usually recommend no stickers for that reason. What our recommendation usually is to place the unique identifier just somewhere at the bottom of the petition, somewhere down here, underneath the circulator block, underneath the warning, things like that, because that's out of our way. When we are processing and when we are bait stamping, and I know this is a recall petition, so it's slightly different, but when we are bait stamping, we're using the top right corner. So we always just ask, don't put anything in that top right corner, because that's where we have the most room to be able to apply Bates numbers in a way that the public is able to see them as well. If you start having things overlap, then there becomes confusion as to which one is which one is part of the sample, not. So I think in general, this is worked pretty well in the last couple of cycles. I actually don't recall last cycle at least disqualifying a significant number based on a unique identifier or anything like that. That's not something we're proposing to eliminate. That's where we are wanting to keep just that same standard going forward that we say. So I think we might need to provide greater language in the manual just to make that clear. Just to make it clear that that's the process. So.
Do you have an idea of what that language is, or is that something you still need to craft?
It is something we still need to draft. We had it in there, but like I said, based on Mr. Grebner's email this morning, I think it might need to be clarified even more. So I do want to go back and take a look at it just to make sure that we're being clear, and so that the public is fully aware.
But there is no prohibition of a unique identifier as long as it's not, like you said, a sticker or in that right-hand corner where you need it. Campaigns, and they can use those unique identifiers without having any issues, as long as they're falling in line with not covering stuff up, all that stuff.
Exactly. Yep. Okay. Yep. Yeah, and we just want to make that clearer as
well.
And if it helps them to monitor their petitions and validate their signatures, it's in our interest.
That's why we don't say no, for that exact reason.
Yeah.
Yep.
Because we want them to be responsible. We're sending that message out. Okay.
Yep, that's why we don't say no for that reason. We just, like I said, we would just always ask that you stay out of our processing way and you don't cover up a mandatory element, so for those reasons. The last piece that I'm sorry, I want to, are there any, before I continue? Okay. So the last piece that is not in the manual that I want to recommend to the board, this is a slight change to process, only to initiatives, to ballot questions. And it's not to how we process the petition, but one of the things that I am going to recommend is related to the approval as to summary purpose and the approval as to form of the petition itself. We currently when we receive a request to draft 100-word summary of purpose, when that comes in, the request is put online for public comment. And it's posted, like I said, for 5 business days, and that request has to be acted on within 30 calendar days by the board. At that same time period, we are having back and forth with the sponsor on form issues. We are having changes being made. We are going over things just that need to be tweaked. The warnings don't meet the statute. The font isn't correct. The size isn't correct. The size of the petition, things like that. So the change that I am going to recommend is that we do not start the summary process until we have a ready-to-go form in our hands, and it's seeking approval as to form, meaning that essentially the request for summary language would be considered received once we have a version of the petition that's ready to circulate to the public. The goal with that is so that way when we are putting it out to the public is seeing the version that is proposed to be circulated, minus obviously the changes to the summary language. And I just want to be clear that that request was something I was going to make even regardless of anything that has happened recently. This was something that we have been struggling with the last couple of times. If you recall, we used to accept language just in like a Word document, and we would put that out. That changed to the board wanting it on a specific petition form. And then now it's, with it both happening at the same time, it's causing more confusion. It's causing changes. We're receiving comments about form requirements that have already been changed, that staff has already caught. So it's not really benefiting either the public or ourselves, and it's a little bit of a struggle. So that is the other change, that is the one change to quote-unquote processing that I would make. I don't equate that as a change to processing like how we review signatures or anything like that. That's just that upfront procedural piece. So
To be really clear on what you are asking, you are not asking us to approve the form in a formal meeting before you work on a summary to bring to us.
that is correct. No, we would not be asking for board approval as to form.
It's just behind the scenes in
Yes.
terms of when it'll be posted for the public.
Correct. Basically, we wouldn't start the summary language until we have a version that we are prepared to present to the board for approval as to form, essentially. I don't know if that made it clear or if I made it worse.
That makes it very clear. So the only impact there would be potentially an elongated period between a petitioner coming to you.
Right.
When would the 30-day clock start then under this scenario? When you first get the form, even though you're making changes to it, or it would start once you have completed that form with them during your back and forth? Once that's done, they submit a final 30-day clock starts.
It would be the latter. How we are currently doing it is the first part of what you say.
Right.
So I'm proposing we consider the request received once we have a final version of the petition ready to go, ready to seek approval as to form.
Makes sense.
So I'm just looking at 482B. Is that consistent with the statutory provision?
I think you would, oh, sorry.
No, I'm looking at it.
So, a couple of things. In a recent change, one of the petition bills that made it through that we did in 23, I believe, it seems like so long ago, there was a change to create this idea of a final submission, meaning that this is the final version of the approval as to form process. And that is a change to section 475 under election law. In regards to 482B, I think you would have to interpret the word request, that we receive a request when you have an actual version of a petition and not just a Word document, for example, or something like that. That we've got a version of a petition that is ready to go through the process, basically. That way we can catch things if language is changing and we don't know throughout, if form elements are changing. That way it's just this is the version that's done, and we're going to interpret 482B's request for us to draft the summary language requirement. We interpret that to mean a request that the request is received at the date that the final submission occurs.
And you've got a sign-off, the sign-off process for a petitioner to submit that and agree that it's the final version.
Yes.
That process doesn't need to be adjusted.
No, that's our current approval as to form
You're good on that.
process.
Yeah, I'm just wondering, looking at 482B, whether you're going to get into a situation where somebody is saying, I submitted this, you didn't either approve or reject within 30 days. But, are we going to be, we're interpreting 482B so as to give ourselves the sort of putting together approval as to form and approval of the petition summary together. And I'm just wondering what happens if somebody who's asking for approval does not interpret it the same way. Where does that get us, I guess?
I have no doubt that an attorney will interpret a provision of the statute differently from each other. So I certainly don't, I'm obviously not the board's attorney, so I don't want to suggest anything other than what my personal thoughts are with this. And I'm not calling you out either. But there is always the risk, right, that somebody would sue. I think that in any time we're dealing with petitions, legal challenges are, as you are aware, frequent. So that is, I'm certainly open to something else if there's a different way. I think the point that I'm just trying to make is that we're having a struggle with kind of having these happen simultaneously. Right. And I don't know, the best way I can interpret it is that. I certainly do understand your concerns as well.
I think it's reasonable, and I think that it's, as long as that is made clear ahead of time to these folks, that's completely reasonable. I do have a question about, well, on average, you say there's a back and forth. On average, are we talking a few days this takes, a couple of weeks this takes? Does it kind of depend? And when you do your back and forth on the form, does it vary a lot? I mean,
I'm going to give my favorite attorney answer. It depends. So it really depends on how many changes are needed. Yeah. We have had some that submit and we don't need to make any changes. We've had some where there's been sizable things that have need to change. Some of them we've been perfectly fine to do it within that 30 days, and others we have really struggled to get through that process, and others we haven't even been able to complete it within that 30 days, and we have affirmatively told them we are not putting approval as to form on the agenda because you have not made corrections and we don't have the copies in front of us. It will go on the next one. So it really does just kind of depend on what the form, the quality, just like what needs to happen, and whether the printers are able to turn it around for the sponsors.
What I hear you proposing, what I hear you saying, which is resonating very well, is if you put this in place, you're establishing a baseline on having a form that meets the requirements before going forward.
Yes.
And that would be clear for everyone, petitioners, bureau team. Everybody would have a clear understanding of what goes into that. You would simply not start the clock running until you had something that met the requirements of the statute.
I would agree with that. And this is something I also want to flag, because I did hear the comments from Mr. Liedl earlier with the other errors. I know there are other individuals that want to talk as well.
They'll address
Yes,
this as well.
so we are not under a legal deadline, so we've got the manuals, we're able to talk about them. If we hear additional changes we want to accept, we can always kind of flush those out now. We can do a draft and we can be prepared for a next meeting. And this is something we can kind of even hear about, we can think about. I don't need an answer on it right now or anything like that. So but this is one thing I wanted to flush out to have a little bit more of a discussion on, to see what the board's thoughts are, what options there may be.
This would be, your intention would be to put it into the new manuals that are being released.
That is correct.
Okay, okay. Any other questions for the director? So what I'd like to do then is to move on. There was a second letter sent in for general comment by Ms. Reckling. However, if I'm reading the papers here, I think, Mr. Wiggins, are you speaking for Ms. Reckling as well? So then what we'll do is we won't have to talk about that. What I'd like to do then is to just move to the comments and open it up.
Ms. Reckling's letter was the letter I was referring to, so she does have comments on the circulator procedure.
Correct.
So I'll hold those for a second. And I was referring, that was the letter I was referring to with kind of the unknown with that judicial manual as well. So I'm glad somebody's here, because I certainly don't want to misrepresent anything either that was being said, so.
That was a gentle way of me segueing to make sure that Mr. Wiggins knew that we still intended to hear from him. And one other item, I have two folks here that would like to comment on each of these. And so, again, going back to the fact that there are two manuals, but it's really a split of one. Just in the interest of time, I would ask that if you've got comments that are related to both general, just speak to one of them. If you've got comments that are related very specifically to petitions or to candidates or to ballot proposals, then identify those so that we know what we're talking about. And with that, I would invite Mr. Brewer. Would you like to share 5 minutes of your time?
Thank you, Mr. Chair. Mark Brewer, I'm of the Goodman Act. I'm appearing in my personal capacity here this morning. I've been appearing before this board since the late 80s as a sponsor, challenger, attorney, and many other capacities for candidates and ballot questions. And I appreciate the board's willingness to continually improve its procedures and process. It's unfortunate that a great piece of reform legislation that we all worked on together was vetoed last winter, but the board has other means to do things, such as through this manual. So very quickly, on the nominating petition manual, I agree it's a great idea to separate the two manuals. I thank you for that. While I have the acting director's attention, because this is not an issue that's directly in the board's jurisdiction, I think it would be a great idea to have a separate manual or memo on the AOI process, the affidavit of identity process. That is not something that this board has jurisdiction over. You have jurisdiction over signatures and petitions, but there is an AOI challenge process, and it would be great to have a document on that. So while I have the acting director here, I thought I would make that point. In the candidate manual, I have two suggestions. First, I would indicate that the staff is available to provide consultation on the form of the petition. That's mentioned in the petition manual, but it's not mentioned in the nominating manual. That's a great service. I recommend all my clients go to the Bureau and have their nominating petitions reviewed by the staff, and the staff has been very generous with its time on that. So I would just indicate that as a note. The second point, and this applies to both manuals, I think one problem we've chronically had is that there's a lack of notice in terms of the challenge process. Challengers are not required to serve their challenges on the sponsors or on the candidates, and vice versa. The Bureau and the board gets all of that, but we advocates and the sponsors and the candidates don't. And, this is a pretty common practice for lawyers in court, right? You serve your pleadings on the other party, right? It's due process. And so I hope we can set up some kind of way that there's a requirement that if I'm challenging a nominating petition, I am required to serve that challenge contemporaneously with filing it on the candidate or the candidate's lawyer. They have to designate somebody to get that, and vice versa. Because I think too much, there's trial by surprise here, which is what we lawyers call it when you don't know what the other arguments are going to be. People show up and they're making arguments you haven't heard of because you weren't privy to the documents that they served. I just think it'll be fairer and expedite the process if that could be provided in both processes, both nominating petitions and the ballot question. On the ballot proposal manual, again, separation is great. The due process notice issue I just mentioned, I support what the acting director suggested, that these processes proceed sequentially. It is causing an enormous amount of problems and confusion when they're proceeding simultaneously like they do now. I have always tried to bring complete, finished petitions as to form when I bring them in and then ask for the summary, but I've seen it. I've seen it take weeks or months to get the form right, depending on who's bringing it. You all have control over the form process, and you can tell people, we're not going to approve your form unless you do it in this order. So, you do have a little bit less control over the summary process, as has been discussed here. That's in statute. But I think you can use your authority under the form process to make this structure work that the acting director suggested. I strongly recommend that you proceed in the fashion that he's recommended. I think it will serve everybody. Thank you, Mr. Chair. That's all I have. Be glad to answer any questions.
Questions for?
I have a question for Mr. Grill. In terms of what Mr. Brewer has just suggested about service of the challenges on opponents, the time for challenges is statutory. Can we make that, I believe it is, yeah. So can we make that requirement ourselves?
It's not required is not required by the statute in terms of the board adding its own requirements as part of this procedure. To some extent, I would invite the acting director to comment on what they think the scope of their authority is. It seems to me like the board's authority to just kind of create that out of whole cloth would be open to challenge.
But a question, it's okay, so I was going to ask almost the same question, so I'll combine mine. The board, the Bureau could become, without legislative involvement or court challenge, a clearinghouse. What I mean by that is that when you receive a notice of a challenge, you could post that notice. So rather than, Mr. Brewer, rather than the petitioner being legally noticed, the Bureau as a clearinghouse, you'd have a place on the website where it would be posted within 24 hours or 48, and those I would think would be internal policies of Bureau of Elections, wouldn't they?
Yeah, I'd be glad to do that. I was just trying to reduce the burden on the board and on the staff. In court, judges don't make sure that things get served. That's the responsibility of the advocates, to make sure that their opponents are served. And again, I will hope we can come up with some process that will survive legal scrutiny. It's just fairness across the board, that everybody knows what's going on immediately and nobody is surprised.
Transparency.
Please, yes.
I agree, it's absolutely, it is makes so much sense. The question is just, and it's a question that we deal with repeatedly. What does the statute say? What do our procedures say? Are they consistent? What can we require, demand?
Could we ask that you noodle on it and come back to us with maybe a paragraph of how that could work?
Yeah, I think that this is also an issue we've struggled with for a while. We try our best to serve them, to use Mr. Brewer's words, because it comes to us and it's not sent. So it does get kind of difficult for us, to be frank, at times, because it's having to, is this something that's being addressed to the board? should we put this to the other party? Is this an issue that's being addressed? Like a challenge is simple, right? When we get challenges in, I think we are very good at serving the challenge on the opposing side, and we're very good at serving responses. Where things have really struggled is when we are getting to the board meeting and I'm still receiving things at 9 o'clock in the morning. At that point, and that's where we kind of get into some of these discussions we have. Some of that hopefully will be alleviated by the board's administrative rules that were passed that are now in effect that require people to submit things to us 48 hours before the board meeting, or else we're not considering it. So that will hopefully be alleviated, and folks are complying with that so far, which is really helpful for us. But now what we're getting, we're starting to get a number of people email us and ask us for requests, ask us in a request to say, well, can I have a copy of everything that was submitted, which is also fine. So I think so the short answer is yes. I think that there's things that we can do administratively. I'm fine if we can think of a way to get there to require people to serve it and kind of leave us out of it. But I think at a minimum, what we could do in the manual is say this is a best practice. This is a request from the Bureau. We ask that you serve the other side, especially in an instance where you know who the other side is, things like that. And then couple that with greater things that we can do as a Bureau for some of these things. We've kind of talked about some website changes, so this is something that we internally have been kind of pondering as to what other way can we do this to make it easier for us administratively, but also just better for the public, so we don't have as much of the comments here where it's, wasn't aware of this, I wasn't aware of that. We can kind of maybe limit that as much as possible, because that doesn't serve anybody any good. So.
Well, we had spoken about that even with regard to some of the public comments that are being received, where it's a formal letter or it's a formal document, about posting those out to the web so that in advance of the meeting, everybody's got a chance to look at it.
Yeah, that's an option. That's one of the options that we've been kind of debating the benefit of that. I think that needs to be coupled with a change to the board's website, because I think if we were just to put them on the website now, it would be even more confusing than it already is. So we are already working on kind of in general updating the board's website just to make it more user-friendly in general.
It's not friendly to us, let alone to the users.
I have heard, and I recognize that. So that is one of the things we're working. So I think when we make those changes, I think that will make it a little bit more user-friendly to be able to have like different things, and that could be an instance where can I use you as an example? If Mr. Brewer submits a challenge, that we would post it online. If he submits a response to a challenge, we would post it online, and that we would just be able to get in the habit of just posting things online. What I would not want to post is if we get just a general email from a member of the public just saying, I support what you're doing, or I'm opposed to what you're doing. I would not want to get into the business of posting that, because that contains somebody's sensitive PII that would have to be redacted, that's got to be withheld. So I think those are things that we can take back and we can think about. And
Like the courts, you all have a docket. And that's who your judges, right? And we can have a docket for each petition drive. Here's the petitions that were filed. They're accessible this way. Here's the challenge. Here's the response. And people can find it in one place. That would be a big help. Thank you, Mr. Chairman.
Thanks for your time, sir. Mr. Wiggins.
There we go. Mr. Chair, members of the board, thank you very much for having me today. I'm Jeff Wiggins. I am a part owner of Victory Field Operations. We're a signature ballot access company started just after the 2022 scenario. And the purpose of forming our company...
Sir, before you do that, would you spell your name?
I'm sorry. Yes, Jeff Wiggins, Jeffwiggins. Thank you. And we were formed specifically to focus on a lot of these issues we're talking about today because the process can be confusing. It can be hard on people who don't have attorneys. And quite frankly, there's fraud that continues to go on in Michigan and throughout the country. So that's why we were started. I appreciate the ability to talk to these two. I don't have anything on number 6, so I will draw those comments. But just a couple things I noticed and that you brought up, Mr. Acting Director. I would just ask that you clarify in these manuals, and you mentioned you're splitting judicial and you're going to be creating one there. The difference between a nominating petition, a qualifying petition, and how nominating petitions can be partisan and nonpartisan, and where that 180-day rule applies. I think there is some confusion. I've had a couple questions from people about, does that apply to a judicial candidate, that 180-day window? So moving forward, I think that would be something that should just be clarified. And then the other one you mentioned was one signature for one office. Obviously, that makes sense to the layperson if there's 2 judges running for 2 spots. But the biggest question that I've seen is, can I sign for somebody running in the Democratic primary while also sign for somebody running in the Republican primary? Technically, you're signing one petition for one spot on each side. I think there's an argument that where people can get confused on that, so that might want to be clarified in there as well, that you can only sign for one office regardless of partisanship or nonpartisan. So, the other thing, I didn't notice in the manual, you referenced the congressional requirement, but another question I've received this time and last time, we have 13 districts and the requirement is half. So I think more clarity in that aspect to say if we have an odd number of congressional districts, it's a question I've got multiple times. So I always say go on the safe side, but I would recommend 50% or more or something to that effect of the congressional district would probably clarify that. And then I did have a question, and maybe this can be spelled out, but when you do sampling for candidates, how does the Bureau sample that specific requirement that they have 100 signatures from 7 of the congressional districts? Because obviously that there's a chance that that's not reflected in the sample that's drawn. So if you do run a full check of that, I think I would maybe just spell that out to people. And if you don't, I would ask how you guys measure if that requirement is fulfilled. And then the rest I have on the circulator challenge, so I can withhold my.
We have, anyone on the board have questions? Mr. Wiggins?
What's the difference between 50% and half?
I'm sorry?
You suggested that it say 50% instead of half.
Well, I was just throwing out some sort of language where it needed to be, but it's, we always say 7, but I would be remiss if I didn't say I've heard that question from many people.
It's a good question, right? Yeah.
They're all great questions and great comments. I would ask if the acting director has any comments to add here.
I think those all make sense. As far as the half, we do say 7 because the statute says at least half. So because half is technically 6.5, and you can't have half of a congressional district. So I think for that, it might make sense just to say 7 of the congressional districts, just to be clear. And you can still cite the statute and say this is the statutory requirement, but then we can just say 7. That doesn't change. It changes once a decade. So with redistricting, like the requirement's there, but the number of congressional district changes once a decade, and for the most part. So I think it might be easier just to say what the number is.
Okay.
So with the rest of them, I think with the rest of the comments, I think that all makes sense to spell out and be clearer on as well.
Thank you for your time, sir.
Thank you.
Mr. Neistat, you've asked to speak again on 5 and 6. We're going to try to get you to speak on both together here.
Neenstead, Clinton Township, Michigan. Frederick, F-R-E-D-E-R-I-C-K, Neenstedt, N-I-E-N-S-T-E-D-T. So briefly, I really applaud the board today for their due diligence in protecting all aspects of this process. As a recommendation, the docket sounds like a great idea when it comes to the initiatives, the citizen initiatives. I would like to clarify, perhaps as a suggestion, that when an initial process is recognized as having begun by the Bureau, that there be two notices, one of a beginning of discussion and one of a conclusion of discussion. And I would hope that would be a relevant suggestion for you. And also, the idea of scanning and canvassing several petitions, especially for like a governor's race, by a citizen or an unfunded or less than well-funded group is daunting. I mean, the time is just not possible. So I'm not trying to do the impossible, but is there any way that resources used by the Bureau to review a large volume of signatures for some violation can be extended to the public? And again, just a suggestion or question. Is there some access that could be made? So I appreciate your listening to my comments today. Thank you very
sir.
much.
Thank you for your time. Interesting question.
I'm not sure what the question was.
Yeah, I kind of want to ask a clarifying, if you don't mind, if I may. The last part with Bureau being available,
Well,
I don't.
it's not lawful to sign duplicate nomination petitions, right? So you have several candidates running for governor. You can't sign more than one. How can a citizen verify that? Looking at an electronic scan without some access to sophisticated electronic software. I mean, conceivably, you could review them.
Are you asking, if I sign a petition for candidate A, are you asking how would I know that I've already
Yeah,
signed
if I'm a
for
citizen,
candidate
how do I know? How do I do the verification? So,
I think what he's asking
He's asking
is,
if the circulator, right?
no, if a challenger, how is a challenger going to know?
most likely a challenger would be
somebody
the
has
interested
I'm
person,
sorry.
absolutely right.
One.
But how do they do that if they don't have access to the same level of sophisticated software? So I'm not asking for the impossible. I'm asking for if anything would be probable as far as public use of what the software is available to the Bureau of Elections.
What you're asking, just to be really crystal clear here,
Mm-hmm.
you're saying that if the software at the Bureau of Elections scans 5 campaigns and comes up with a list of duplicates, what I hear you saying is, can that list of duplicates be provided?
Absolutely.
Is that
You
the
know,
question?
that would be the simplest way, but I don't want to go beyond what is legal for the Bureau of Elections to do, right? If no one's challenging, I mean, we have a responsibility too as citizens, right? But is the responsibility within our grasp is what I'm trying to present.
I would like to ask Mr. Fracassi whether the Bureau does identify duplicates, because it's my understanding that it doesn't.
That was the last conversation we had, yes.
That was actually one thing. We unfortunately do not have a software, as
was getting to that
it's all a manual process. So we don't have anything other than Adobe, to be honest, that puts it to a PDF so we can put it online. Processing petitions is still very much a manual process for us. And as far as like duplicates, that is one thing we leave to challenges, just because we don't have the ability. We can tell within sometimes with the drive, it's easy, right? If somebody signs line 1 and line 2, that's easy to tell. But we usually leave for a challenge to compare that whether or not I signed a petition for candidate A and candidate B, and I wasn't allowed. It's always my hope in the future that maybe we could get a software that would be a little bit, but we don't have anything at this time, unfortunately.
Maybe that's where we should focus this part of the conversation, or defer that. And we've had that conversation before about software packages that were sophisticated enough to pre-process your data in ways that would give you high-speed access.
Yeah, I think that's definitely a long-term conversation that involves like the full DTMB procurement process. So, yeah.
Thank you very much.
The answer to you is absolutely, but not today.
Within realm of possibility, yes, okay, thank you.
Christmas is coming.
Yeah, I get it. I do see a lot of signing of petitions, thank you.
Thanks for your time, sir. So, a quick pause. It's 12 o'clock, and I'm not going to go beyond that, except that we've talked about 5 and 6, the two parts of what's today one manual, which will now be 2 manuals. And we've heard from everyone who's asked to speak. Each of you that have spoken has asked to speak to both of those issues. And I'm putting 5 and 6 in a basket here, not 7. We've heard that there are some changes that we still want to consider making.
So we don't need motion.
Yeah.
So we don't need motions on this, but, so I would guess that what I'm asking of my fellow board members is, shall we simply ask the Bureau to make the changes that we've talked about this morning? Make the changes you want to make, and then resubmit those changes, that modified set of manuals?
That's completely fine with me. I will say out of all of the specific changes to the manuals and things like that, there's nothing that I'm concerned by or am like, so I'm happy if we want, I can like kind of read through the specific changes if you want, but what I would recommend is we'll make the changes and then resend it to you guys, and we'll post it online as well. Again, we'll post an updated version. We won't be able to do an updated, like a track changes version online, just because that doesn't, it always gets deleted for some reason when we put it online, like the changes themselves. So it's very difficult sometimes, but so I just like briefly at a high level, what I heard from the nominating petition manual is just making clarifications of staff consultations, explaining the difference between nominating petitions versus qualifying petitions, partisan versus nonpartisan, the half requirement for congressional district, clarifying how we check the district, that congressional district requirement, the signing one office regardless of partisanship, plus the 180-day requirement. Then we've got the judicial manual piece as well that we already talked about. Figuring out something to do with the challenge process, both administratively, but at a minimum, we'll put in the manual, ask that it be served on everybody and not just sent to BOE. And then for the ballot manual specifically, we'll continue to explore what we think as far as the proceeding sequentially with the approvals to form summary language. And then I've got the change on page 18 and the change on page 8 that Mr. Liedl said. And then I separate from the manual, but the creation of an AOI manual or something to kind of clarify the AOI process. And I think that's all. And then plus the clarification with the unique identifier. Sorry, I missed that one as well.
Thank you very much.
I missed anything?
When you put these changes out, when you make these changes, if you can't provide a tracked version of the document, would you provide a sheet indicating the changes that you've made?
That might be the easier way, yeah, for us to say, like, add it on page 8, like,
do that?
kind of say, this is what we added and call it out. And then we can send out the clean version as well to our mailing list as well as the board.
Perfect. Does that work for everybody here? Yes. Good. So no action required on 5 and 6 other than what we've talked about. No motion required on 5 and 6. Item number 7 is a little bit different. It's consideration of a new document, which is wholly new, of the proposed procedure for circulator signature challenges. And Mr. Acting Director, would you?
Is he acting director or deputy director?
Well, I think he's acting right now, aren't you?
So my
We're very liberally using your new title.
It's all good. So in my regular job, I am officially the Deputy Director of Elections for the state. So I'm the Deputy Director for the Bureau of Elections. What my position description says is that in instances where the director is not available, I technically am acting director. So I personally just use deputy just because that's my habit.
You know, I've been using acting since we went through all of the
It's
motions.
accurate to say that I am acting. It's just as accurate to say that I am deputy. Right now, I'm kind of serving both roles, so.
And I've seen the letter that actually used that, so yes, okay.
All good.
If you would, could you walk us through the new document?
Sure. So this is a new change as well. So one of the things that we want to do, because this whole process with challenging circulator signatures is a new process for us, what was important that we wanted to do was document it and put it out to the public, so that way there's just expectations on how this will work for everybody. So I'll kind of walk through it at a high level, and then we can listen, any changes as well. I'll start first with a very general timeline with this. I don't think that this one is, I'm going to rephrase that. So this one is geared really more towards that challenge period, which comes a little bit later in the process, whereas the manuals are relevant for folks now. They're out there circulating petitions. They need to know the manual, the requirements that the manual lays out. So I say that to mean if we need to if we have a discussion on this, we're okay time-wise. So I'll kind of walk through it at a high level. We'll talk about some of the things. We, again, posted this online, I believe, for public comments. That's what I thought. Okay, thank you. I don't believe we got anything in advance of the meeting, like any specific, like line by line, like we did with the manuals. So I'll just kind of walk through the process, and then I believe you also said you've got folks that want to talk about it as well. So in general, what we did was document everything that we did for the West investigation and tried to just basically make that into a clear procedure. So the starting point is that if you're going to make a challenge to a circulator, the validity of a circulator signature, that there needs to be a threshold for evidence. What we need to have is some sort of example. So for example, to say that Adam Fracassi signed this petition and my signature appears this way, and I signed a petition over here, and it's night and day. It doesn't match. That's something that gives us something to look at, rather than just saying at a high level, I'm challenging all of the signatures in this drive from all the circulators because I think they're fraudulent. So there has to be some sort of threshold requirement. So, and to be clear, I'm not suggesting in any way that was done here. Just wanting to document what that threshold is for us to go down this road. So, so that's kind of the starting points, needing something. And then from there, what we will do when we get it is that we're gonna take what we can to try to investigate, take what steps we can to investigate. We're gonna ask for evidence like we did with West. We're gonna ask for an exemplar, especially in the instance where the circulators are out of state. We don't have anything for these individuals, so we're gonna reach out and we're gonna ask for information. We're gonna ask for some sort of document that shows us what the signature is. That can be in the form of an affidavit. It can be in the form of like a copy of the driver's license, something like that. So that way we have an exemplar that we can compare to. We may reach out to, and when I say we here, I'm using this as the board to be clear. That the board may reach out to an individual circulator. We may do it in the sense like we did with Mr. West, where we reach out to an attorney and say, these are the people, please respond. But we will take some sort of step to get the information that we need in order to make that conclusion to say this is this sufficient or this does not sufficiently agree. In order to make the determination as to whether something sufficiently agrees, we're going to use the same standards that we use for voter signatures, a voter signing a individual line. We'll use those same standards to determine whether or not it sufficiently agrees. That's what's all spelled out in the manuals already. And that depending on kind of the next steps, there are certain actions that may be taken. If we see something at a higher level, you've got, like we talked about today, you've got the penalties that are outlined under law. We may refer something for further investigation like we did to our Office of Investigative Service. If we get to a point where we're at a point and we're not getting any further, then we're going to take steps to try to get more information as possible. So as far as a timeline goes, what the Court of Appeals indicated in the lawsuit, like I've already mentioned in the Holiday case, that it does not, this investigation is not required to be completed in order to make a determination of ballot access status. In a perfect world, would that happen? Yes, but we also, the court recognized that there are difficulties in doing that. There are difficulties because of just the tight timelines in having to verify signatures and commence the canvass process. And that depending on the scope of a challenge, it may be possible at one point, it may not be possible for another. If evidence is submitted sufficient to commence an investigation against 2 or 3 circulators, that's very different than against 55 or whatever the numbers may be. So that timeline may vary depending on the scope of what we're talking about, depending on whether or not this is a individual that we have something on file, like in the qualified voter file, for example, versus not. So, so once we've completed the investigation, then that's when we get into the penalty section, like we've already kind of discussed this morning. And those are outlined under the last 2 pages of the procedure as well. As to what the board's authority is to do with this. So that's at a very high level, the process, and then I am happy to answer any questions and also open to any refinements, things like that we can do to make this as clear as possible. So.
Open it up to you, board members.
I don't see that there is much of a procedure set forth in this. It just, there's no timeline, and it doesn't really put any pressure on the challenger, on the sponsor or the candidate whose circulator signatures have been challenged. So it seems to me that at the very least, if there is a challenge which is supported, that there needs to be a very quick response required of the sponsor or the candidate. You've got, here's some indication that your circulator signature is not valid. Give us within a few days, whatever. Give us a handwriting exemplar. Last time we requested it, and obviously the time period had passed. But we're talking about what we do going forward. And I think we need to say, okay, in this instance, we need to have a handwriting exemplar submitted very quickly. And if it's not, we're going to subpoena it. Or perhaps, if you do not submit to us the evidence, we're going to draw some conclusion. Sort of like the burden shifts. We're going to, it would seem that that if you're not going to give us the evidence to say that this is a valid signature, that we're going to assume it's not. I mean, that's not necessarily what I'm suggesting, but I think that these possibilities need to be explored. And I also have a question about something that you said on the first page, that if you see circulator signatures that don't agree with each other, that's not sufficient evidence. It sure seems like sufficient evidence to me.
Yeah, so let me clarify that. So it's not necessarily, I'm trying to think of how best to explain it. So that's, I would say, sufficient evidence to submit a complaint and say, these don't match. But when we're determining whether or not they're invalid, we're not going to discount all 10 because of that difference. We will certainly say, the general practice, like what we did with West, for example, with the individuals, if you have 10 and 7 of them look one way and 3 of them look a different way, we're going to say those 3 are wrong, that they don't match, and there still are conclusions that like we can reach, the board can reach and things like that, but we're not going to invalidate all 10 per se. We'll take, if the majority is this way, those are the ones that we're going to consider valid. That can be changed. I mean, that's kind of, so we
I see
modified
what
that
you're
based
getting at.
on.
It's sort of like, you're saying if the majority of the signatures from a particular identified individual,
Yes.
if the majority are in one handwriting and some others are not, you're going to credit the majority as being valid.
Yes. We're going to presume that's and then the other batch, we're going to say, clearly something's not right with this batch.
How big a majority?
But I think
We
we've got to be a little cautious here how we're going to, because I can see, I told you my adventure. I went to the Secretary of State in person to get my driver's license, even though I didn't have to. I could have done it online. I did that to check out this new process of special license. I'm telling you the story because one of the comments that she made to me, the young lady that helped me, was she said, "Oh, you have a very nice signature. It's different than the one you had 4 years ago." And she's right. She's making a valid point. She said, it's different signature. That's a change over time. The change with this, when we're looking at individuals signing this, electors, they're only going to sign one time, and you've got an example to work with QVF. Circulators are a different animal. They're going to sign multiple petitions. They may be signing one out in the rain in front of the library. They might be signing one 5 minutes before it has to be delivered. They might be signing one in a community environment. Without any specific stories, they could be signing it at happy hour. The point being is that you're saying that if there's a couple of signatures that don't look legitimate, you're going to rule on those individually, and only those sheets will be disqualified.
That's correct. Absent some, there's also still built in with any process, like a rebuttal period.
Right, I
obviously.
get that, but I'm saying
yes.
that on the whole, no, I think you're taking a wise course there, because to have 2 signatures that don't look right from someone who signed 20 sheets, I think it would be unfair to get rid of 20 sheets. I think you have to base it on individual examples. If you have 2 signatures that don't look right, or 1 signature that doesn't look right, or 10 that don't look right, evaluate them on the individual sheets.
Yes, that's what we're proposing. And if we need to clarify that, if that needs to be made clearer, yes.
And I'm not suggesting you're changing that. I'm making sure that that's exactly where we're headed, right?
Yes.
I heard something different earlier in the conversation.
Did I say something before?
I was misinterpreting perhaps
No,
what
I
you
may
were
have,
saying.
but, I was just really puzzled by this sentence because, it does depend on how much of a discrepancy there is in the signature over a number of petition sheets. And what we're going to be looking at is the sample, right?
Correct.
We're not looking at all of the petitions, but there does need to be, a challenger is going to be looking at this smaller universe of samples petitions, and it's going to see circulators' signatures. And I would hope that it's not just the challenger who is looking, because the obligation is ours, right? And the obligation, but it is the Bureau which is serving as the director is our secretary. The Bureau was working for us. And so the Bureau could also be, and I would hope would also be, taking a look at these signatures, and if there are a lot of circulator signatures which are not in the same handwriting, the Bureau ought not to wait for a challenger to say that. The Bureau ought to be saying that. And this is what happened in 2022. There were challenges to petitions, but the Bureau also noticed a lot of forgeries. And so it is both the challengers and the Bureau which are looking for obvious signs. And that's one of the terms that we use, obvious signs of forgery.
Yeah, and I think it's a little bit harder with circulators just because you with the requirement that you don't have to be registered to vote in Michigan to circulate a petition. Excuse me. It just is a little bit more challenging because we don't have anything to compare to sometimes for that reason. So that's, I think, there is a balance. I do agree. There is definitely a balance with it. And I think with like this, the one point I don't remember what you had said, but the other thing I wanted to flag was that if we are checking these in the sample, and if we say out of that 10, 3 are invalid, that is still going to be extrapolated out as part of the sample as well, because we're going to invalidate that sheet, which then has downstream consequences with the sample. Just as we would say, if right now with a circulator, if the date's not filled in, we invalidate that circulator sheet, which then is extrapolated out to represent a total number in the whole universe of filings. I don't know if that made sense at all. Chalk that up to my lack of coffee still for this morning, but that's kind of why we want it, rather than saying like we'll do all 20 or 10 or whatever the number is, we are going to do that individual parse out, because that one signature represents something more in the universe, in the sample.
And in the case of circulators, that could be extreme, because you're going to extrapolate each individual sheet that you found an issue with in the sample.
Yeah, because like one sheet will represent a certain, like one signature, like on that, like we sample, you pull that sample, you get that sampled signature. That one signature represents a number in the universe, depending on how it gets filed. It can be, let's say it's 500. So if we invalidate that one, then you are essentially invalidating everywhere else as well for us, that same number, and bringing those numbers down with how the sampling process works. So, and that's not to say too, this is partly why, because of the changing with signatures too, the board's practice is always recommending an affidavit be submitted, because that's a little bit, it takes that into consideration. We do on the voter side, when we're looking at comparing signatures, we do also take that into consideration as well. If we've got a signature on file that is like if it's 20 years old versus last week, we do consider that handwriting changes over time, right? Somebody's hand might be a lot shakier as they're signing a petition form than it's going to be as you're in, and then when you're in a branch office signing on the piece of paper or on the stylus. So we do take those into consideration as well.
So let me ask this. So when the challenge is made, how much time do we have here? Is there a specific time, or does it depend on when we have to, when do we have to make a decision based upon this challenge? How much time do we have?
So the challenge would have to be submitted for a non-sampled candidate 7 days after the filing deadline. This is when the initial challenge has to come in. And then what we have done with sampled candidates, it's 7 days from us publicizing the sample. From there, we have, I believe it's 58 days from the filing deadline, I believe, if I remember correctly, to meet and certify. So it's like roughly 2 months.
To certify to the ballot. For
Correct.
the primary.
Correct.
Okay, so we have quite a bit of time.
I wouldn't go that far. It's a quick turnaround. It's a really quick turnaround, because we also have to draft staff reports. We also have notice requirements. So that in that 58-day window, we also lose 7 days for posting a staff report under when it has to be posted and we have to schedule. So realistically, we have I would say 45-ish that to be done and to have a board meeting. And that's just before the certification. These investigations do not technically have to be done before the certification meeting. These can be
Right,
carried over.
but you would prefer that they be done before the certification meeting.
It would,
I would
it's
prefer
ideal, but I just want to, it may not be possible.
Okay, but what can we do to make it more likely than not that we're going to be done before we have to decide whether there's, sufficient validity? So, so we get a challenge, and it looks like a meritorious challenge. Then it seems to me we ought to have a time for requiring a response from the challenged, whether it's a ballot question or a candidate, to respond. Okay, give us the handwriting exemplar. That's
The easiest way to answer your question, the easiest solution that we've all talked about is for a circulator organization to pre-qualify who's going to go out. If you're going to bring somebody in from out of state, or if you're going to bring somebody into the state, and you have a circulator that's going to work for you, have them submit their driver's license or have them submit their documentation. I think we've talked about this a number of times. We've had conversations about saying, should we be talking about getting circulation companies, paid for circulators, register with the state, and what can be applied there? I remember those conversations.
Those certainly have come up. I think when it comes to requirements on circulators, the board's authority is probably a little bit more limited without a statutory change. I think we certainly can add like best practices to this as well, to say like some of what you have just said, like when it's a best practice to gather this information up front, because, and like Vice Chair Gerwitz said, if you don't, like, here's the consequences that come down the line, things like that. I think we can spell some of that out more in here and say like a best practice would be to get a signature exemplar when they submit the petition sheets to you. Have that ready to go. As far as a timeline goes, I would put no more than 7 days on it, and I would say 7 just because that's the amount of time we give for response for all other challenges under it.
So 7 days to submit an exemplar.
Yes. Yeah, we under
And
current
if you don't,
will proceed with what we have, and which may include making decisions based on the evidence that's in front of us.
right.
So how we currently do it with challenges to petitions is we send it out. So let's say we send it out on a Tuesday. We are going to notice the candidate. We're going to say we've received the attached challenge. You have until X date to respond to us. And then, so I would follow that same structure with this and just say, this is what's going to happen. And if you don't, then we're going to proceed with what information we have in front of us.
Is it even in the realm of reality to look for a day when a circulator could register on the state website, regardless of what campaign they're involved, register and say, you know what, I'm going to go out and collect signatures for an organization. I'm going to register. Is it even in the realm of reality to look for a day when a circulator could register on the state website, regardless of what campaign they're involved, register and say, you know what, I'm going to go out and collect signatures for an organization. I'm going to register on the website, I'm going to put in my information, my state, I'm going to submit a copy of my driver's license or another signed document, and now there's something in the state file that says, hey, it's not the QVF, it's almost like it's kind of the same model. What would have to happen to make something like that work?
One, a law change, probably.
But that's okay. I mean, we've done that
Yeah,
before,
I
too,
mean-
where we have these conversations, right?
Yeah, you'd have to, I mean, what I think you're basically asking is like a circulator registration requirement with a little bit more teeth than just beyond, like we've got at the top of the check boxes right now. That gets a little unknown because we do have the Supreme Court case that said the affidavit requirement was unconstitutional. So that would really be a question for the legislature to figure out what is and what isn't. Like what are the parameters with what they could do versus to be in compliance. and obviously there's other factors that go into a court making decisions too. Circumstances may change, things like that. So I would defer. But long story short, I think the first thing that would have to happen would have to be a law change to implement some sort of registration requirement. I think other states do that. So, it's not unheard of. I believe at least I can think of at least one other state, I think, that has some sort of registration requirement in advance, but it is a tricky line because there is U.S. Supreme Court precedent on that as well that says the speech between a circulator and a voter is protected speech, and if you go too far with that, then you're violating that speech right. So it is there's a line like everything else, right? So it's a little tricky requirement.
Candidates' use of circulators, whether they're paid or unpaid, is also protected. So, so we have to recognize that. But what we're trying to do is ensure that the candidate or the sponsor is responsible, right? So in terms of best practices, to say, you may be asked, in the event of a challenge, you will need to submit an exemplar, a handwriting exemplar for your circulators. So have that available, right? So that, you can't perhaps you can do it as a matter of procedure, whether you need to have statutory changes, I don't know. But best practices, to have them, to tell them that we expect them to respond in a very timely fashion if there is a challenge.
Yep.
That makes a whole lot of sense to me.
Yeah, and I think we can absolutely do that as a best practice. Like that's, and we
But it
can
also,
say,
right,
and we can put it in
matter
there.
of
Yep.
procedure.
Yeah, absolutely. Yep.
I think too, there's a lot of, I'll just say even from just what I've seen, I think that some of these best practices that we're talking about, I think it's good to put in paper because I think that these things are already naturally happening based on what's happened over the last several years. So it's becoming less of a wild, wild west, definitely still a wild, wild west in some regards. But I will say, this is kind of going in reverse a little bit. But I do think that the policy of evaluating each of those individually is good because what my concern is this is a little bit different from when you have forged signatures of signers, right? Because when you're kicking out an entire petition because of a circulator forgery or reason, there could still be valid signatures on there. And those people have constitutionally protected rights if they believe that they signed it in good faith, right? So I do think taking a little extra concern in this regard when it comes to evaluating those, and if there's 2 that are bad but 8 are good, and if those signatures are good, protecting those people's rights to sign that petition are extremely important as well. So I firmly agree with the way that you guys are approaching that.
I do think we need to take into consideration that we are going to have a huge number of petitions, both ballot questions and nominating petitions. And that means there's going to be a lot of competition, right? And there are going to be a lot of circulators out there scrambling. There are going to be a lot of sponsors out there scrambling for companies and circulators. And so letting them know, this is important work, and don't just shove junk.
Well, and letting them know that this has become at least from what we've seen in the last few years, this has become a strategic option to how to knock out the competition. And with sampling, that's simply going to be more magnified, I think. So any steps we can take to make it logical, but.
Well, we do think that sampling is going to give us a much better
handle on it.
Much greater degree of confidence in the validity of signatures.
Are we at a point where we could enlarge our conversation? And we have 2 folks that would like to speak on item 7. Can we do that? And both are attorneys or representing. Mr. Brewer.
Thank you, Mr. Chair. Mark Brewer, of Goodman Acker. I'm appearing again in my personal capacity here this morning. I'm very concerned about the proposed procedure because I worry that it actually invites circulator fraud because it does not do anything to punish by disqualifying signatures. And I'm just very concerned that candidates, sponsors, and the Dillahunts of the world are going to be encouraged by this procedure, not discouraged. I have a proposed alternative to it, but let me talk about what's in front of you first. In terms of the timeline, I think the Holiday case is being misread, frankly, here. The issue in the Holiday case was your duty to investigate, and the court clearly said you have a duty to investigate. We didn't ask the court to set a deadline, and so the court didn't. And so to read the Holiday case as saying there's no deadline for the board is a misreading of it and defies the statute. The statute is very clear. In subsection 8, it says if the Board of State Canvassers receives a sworn complaint in writing questioning the genuineness of the signature of a circulator, it shall commence an investigation. Crystal clear. You have to investigate. That's what the Holiday case enforced. But then if you look at subsection 10, which was not at issue in the Holiday case, at least 2 business days before the Board of State Canvassers meets to make a final determination on challenges to and sufficiency of a petition, the board shall make public its staff report concerning disposition of challenges filed against the petition. There's no exception there for challenges to circulators. It's all challenges have to be resolved in the staff report that's given to you before you make a final determination. And there's ample time to do that. So I think it's very important that the timeline be constructed in a way so that you can resolve all these and have this for you. Sure, there are other penalties. But as we saw earlier today with the West campaign, after the fact, it's meaningless. Mr. West made the ballot despite the signature circulator fraud that we saw. And so, that's just going to be the cost of doing business for campaigns. They're going to say, well, we may get caught, but we'll deal with it after the election, after our candidate is on the ballot, or after our proposal is on the ballot. I think it's critically important that a structure be created so that all of this is decided before you make a determination on what to do. There are a number of things in the procedures which I think are correct. It is incumbent on the challenger to identify the specific circulator signatures in the sample. That's what we did in the Holiday case. We provided examples of how these circulator signatures differed. In some cases, we actually had signatures from other petition drives. And I'm glad to see that the procedure says, yes, we will consider any example of a signature. And I would also note complaints are verified. So you have some protection that when the challengers are making these allegations, they're not just making them up. They are saying, we took this signature from this petition drive, from this petition, and it doesn't match the one in the sample. So I think that's a great thing about the procedure as well. I think the board and the staff need to take a broader view of how many signatures would be disqualified. I mean, once you have provided evidence that a circulator's signature is in doubt, that affects everything that circulator filed, because at that point you don't know which signature is valid. You don't know which sheet has the correct signer on. I appreciate Mr. Cordes' point. I agree with it. We've got to be concerned about the signers here. They have rights as well. But part of the process, and again, going back to the sponsors, going back to the candidates, it's up to them to ensure that their circulators are obeying the law and protect the rights of those signers. That's how this should be structured. So I would propose this as an alternative, and it's similar to what you've heard Ms. Gerwitz suggest this morning. The challenger has to submit examples. You just can't come in and say, we think Brewer's signature is forged. You have to give examples of why Mr. Brewer's signature doesn't match. And so you got that. Then you've met the threshold. Then I think there has to be a very tight deadline for the other side, the ballot proposal, the candidate, to respond with an exemplar. Very tight deadline. Frankly, what I would do in this situation, and I hope we're moving toward this, I would require all of my candidates and all my ballot proposals to prepare an affidavit of each circulator that we would then have ready to submit in case the Bureau asks, well, what about this signature? Here's the affidavit. So if we know what the procedure is in advance, the candidates and the sponsors of petition proposals can make preparations to anticipate it. Not only should they clamp down on their circulators, but they can have the exemplars ready to go in case there a question is asked. And if you don't respond to that demand from the board, the staff, for an exemplar, then you proceed as Mr. Verkasi indicated. You make a decision based on the evidence in front of you. You've had a chance to respond. You failed to. Obviously, if you submitted evidence, the staff will consider it. But I think there have to be consequences, and you can't let the sponsors of the petition or the candidate drag this out so that they never have to respond. Let me just conclude this way. As you all know, you're the guardian of ballot access in this state. I know you take your jobs very seriously. You are going to be tested this year by both sides of the aisle because there are ballot proposals that one side of the aisle doesn't want on the ballot, the other side very much wants on the ballot, and vice versa. And it's going to be up to all of you to fairly enforce those rules. I believe everyone should have access to the ballot, but they got to play by the rules, and that includes circulators, not just petition signers. So I urge the board not to adopt this policy today, but let's have further dialogue on this. Let some of us practitioners have a say in this. I appreciate that it was posted. I appreciate all of that. But I think we need to develop a way so that circulators are monitored and there can be challenges, and those challenges can be resolved before you make a decision whether to certify a proposal. Thank you, Mr. Chair.
Thank you very much. Good. Mr. Wiggins.
Thank you, Mr. Chair, members of the board. Jeff Wiggins with Victory Field Operations, JEFFWIGGINS. You have in your materials some of our comments related to this, and it's basically focused around timing. And I'm not going to go into agreeing with Mr. Brewer because I tend to try not to do that sometimes. But he does have a point. I think whether it's the statute, whether it's this policy, there needs to be some clear timing frame here, because you could get into a position where you catch one person doing some nefarious stuff and you do it in an ample amount of time to remove them from the ballot, and then the situation you were reviewing today where we're almost a year past the election and we're finding stuff and there's no quote unquote justice there. So I think it does have to be specified. There does have to be clear guidelines, and for the efforts in the interest of transparency, to make sure everybody's playing by the same rules. I do want to take just make a note of caution that requirements on whether it's candidates or committees that are being challenged. Putting some sort of requirement on them to submit information in a timely manner, I think is fair. I think we just have to be careful that those requirements don't come with heavy-handedness to where this can be used as a political tool to maybe just throw stuff at the wall to see what sticks. And the only reason I say that is because I was made aware of a situation last year where a judge was trying to get on the ballot and somebody challenged all the signatures and threw everything they could at the wall, even to the point of claiming one of the circulators was deceased. The circulator had to take a picture with his phone bill and send it in. And it's funny, yes, but at the same time, that's the time the campaign has to take, the candidate has to spend on attorney fees, stuff like that, to where you just want to make sure that the accusations that are being made can be verified and that it can't be used as a political tool to slow down the process. And everybody's trying just to get to a fair way of operating. So for the deputy director, one thing I might suggest in this process is when we're reviewing petitions to ensure that everybody is abiding by the rules, yes, look at the signature, and it can be different from time to time, but you can also incorporate the rest of the circulator field, how they're filling out the address, city, state, county, and that's where we tend to find if somebody's not doing it. That's where you tend to find that the fraud is there. Just it's easy. It's harder to mimic handwriting line after line after line. It could be easier to mimic a signature depending on the dynamics of the signature. And finally, I just want to say I do agree with Mr. Brewer's sentiment from earlier today that there needs to be significantly more enforcement in this area. And the one example I think that has been brought up last time before this board was that our company found a couple first turn in. We didn't turn in any of their signatures, but it was very clear to us that these were forged, that they didn't do the right, they clearly turned in bogus signatures. We called them out on it. We turned it into MSP. We alerted the Attorney General's office. We alerted the Bureau of Elections, Secretary of State's office. We never even got an MSP report. And so we did this for about 5 circulators last cycle that we caught. And I know the money's not there, the staff isn't there, I get it. And you want to come down on the circulating companies and the candidates. But at the same time, I would just advise you try not to punish the good circulator companies and the good candidates who actually do this when they self-report, they self-enforce, and yet nothing is done. And so we just get lumped in with everybody else. So that is one thing I would ask and encourage, hopefully, that there can be some sort of, while also going after bad actors on the candidate and firm side, that you also go after individual circulators as well, because if they're not punished, they're going to keep doing it. So that is all I have. Happy to take any questions.
I'm sure you're going to turn in great petitions, which
We
have been
do
validated.
we do our best. We do our best. And we do take some of the precautions that were suggested earlier. We sit down, we get the photo IDs, we do all of that stuff. And if anything ever comes up, we put a pause on all processing and we say, all right, we're going to audit these, and we sit down and everybody goes through it. And so we do as best we can. And I just think it's a process that everybody, that was my only plea, is try not to lump the good actors in with the bad actors.
Thank you very much.
Thank you.
So this is not something that we're going to motion or approve today, but this is a document that's got a good start. There's some work that has to be done. But you know what? It also comes to me that out of all the discussion this morning, there also seems to be a lot of questions that still need to be asked that we may not even have the answer to, legislatively, for example. A lot of ideas got circulated. I guess I would see us moving forward on this more from keep the discussion going.
Yeah, that makes sense to me. One thing that I think we could do, I have a list of points to add, things like that. So I have kind of like adding in some of the more timelines. I think we can put in some better best practices in here, like have been talked about, some ideas of exemplars, like using the affidavit, kind of going over some of those. My thought with this is that we do some of those and then put it out again for public comment. And maybe not in the July 31st meeting, maybe we circle back to this at like the board's meeting in August. So that way it has time to be in the public. We've got time to incorporate anything else as well. And then in the meantime, if people want to submit like more specifics with what we have out there already, they can. But I don't think we'll be able to turn that around that quickly. And I actually would like to have more feedback from like what we put out and to say, does this still make sense? Like, are we hitting at that point? So,
So let me ask a question from a circulator standpoint today. And if I missed this in the literature, forgive me. But so let's just say, for sake of argument, that Mr. Brewer comes to us and he's challenging a circulator or a set of circulators. And obviously we have a responsibility to investigate. But if part of our process were to simply say, okay, if it's challenged, the circulator company is required in so many days to provide a sample. as an additional step. And if you don't provide the sample, that's fine, but if you don't provide the sample, then we're going to assume that signature is bad. Is that the kind of direction that we need to be talking about? I mean, it's something that we could put process in place that basically, it's a default argument.
Yeah, I think it's, I think a little bit, yes. So I think essentially what we're saying is that if a challenge to a circulator's signature gets made, and if we get an exemplar provided to us, that's easy, right? If you get a sample, we've got petition signature exemplar, that's easy to say, does this match, yes or no? I think in the instance where we have nothing, then the question is what to do. I would not presume solely because we don't hear anything that is automatically invalid. What I would say is that is then incumbent on, as part of processing the challenge, to evaluate it with what's in front of us. We may have nothing in front of us except for circulator signed petition number 1 here. This is what their signature looked like, and they signed they signed sheet number 3 for candidate B, and this is what their signature looks like. Like, if you've got a one-to-one comparison like that, I don't know what would be valid in that instance, but at that point, then it might be, do we have a match there? Like was brought up with the circulator block, like that would be all part of the evaluation that we would take into effect, and to present a recommendation to say, this is what we found, we've got this, like here's kind of where we're at with that. So I think like that's kind of, I think that would be what I would say. I wouldn't necessarily presume solely because someone doesn't respond that it must mean that it's fraud. I would take that next step because of a lot of the same reasons that Member Cortez mentioned. I think we have to take that next step and try to evaluate based on the evidence.
I mean, if you went that direction, I would expect you would have a matching process that would be a notice process. So if you're lacking an exemplar and a signature's been challenged, notice the campaign, or notice the signature company, or notice the organization you need that exemplar from. Put the onus on them. If Mr. Wiggins goes out and hires 10 people and pays them to gather signatures, we're making the assumption that he's providing some level of management expertise to do that. So if he's noticed now and says, hey, you know what? Adam doesn't have we don't have a sample of Adam's signature, and his signature's been challenged. It seems like a fairly easy process. I know I'm making it oversimplified, but one process would be, in part of that challenge period, would be to notice Mr. Wiggins as the organization or as the campaign, and say, we don't have Adam's signature. You've been challenged. You have so many days to provide it.
That would be the very first step when we send the notice. Like, I envision in the letter that we're sending to say, we received this challenge. Again, here's the copy of the challenge. Here's what we need from you. If you don't provide it, here's the potential consequences. Like, I would do that all up front because it's a very tight window, and these are not the only challenges we have during this time period as well, in addition to just having to process petitions.
Right.
So there definitely is that balance on Bureau staff to do this, and the Bureau's availability given the resources that were provided. So I would want to front load as much of that as possible to say, the challenge deadline period has passed. Here's a copy of what we've received. This is what we need from you. This is the deadline we need it from you. If you do not provide this to us, this is what's going to happen. Like, here's the next steps, and we're just going to proceed.
It's a really clear pattern to be able to say, Mr. Wiggins didn't provide the sample, you couldn't review the sample, it comes in front of us, we say, all right, that's out.
And that's how we would handle it, yeah. So like if that happens, we would do the staff report, we would be presenting it, and then for a recommendation and decision by the board, like we do with the other challenges. We would just lay it out and say, we noticed on May 1st, deadline expired May 8th, no response was received. These are the steps we took. This is our evaluation. This is our recommendation.
And I would think that most companies, especially if there's money involved with a candidate, most companies, correct me if I'm wrong, would take the preemptive step of saying, if we're going to hire 10 people to go gather signatures, we're going to make sure we know who those folks are. I mean, you must be getting some identifiers from them anyway because you're paying them, right?
And if you're paying them, you have a W-4.
You already have that, maybe.
Right?
Well,
Unless you're paying them under the table. But I'm not
That's a different
suggesting that
conversation.
that would be done by any reputable ballot sponsors.
I mean, that's the one I keep getting hung up on here. For all of the times we've heard this come before the board is when somebody says, well, we've had signature gatherers who are making a wage and they're being paid, but no one really knows who they are, or nobody can prove who they are. That doesn't work. I mean, that's not a plausible argument, I don't think. So all we're really doing is putting some common sense in, right?
Right.
So with that, we don't have any action to take. We'll put some notes together, add it to another item.
And then I will, in the meantime, we'll make some changes, and then we will post it again. We'll kind of like solicit more public comment as well.
And this one it's fair to say number 7 is not going to show up on the 31st.
I probably wouldn't, I mean, if you want, we can, but I would probably have to cut off that additional round of public comment, just because
I like it if you kind of push that one out a bit. We don't have an urgency on it.
and I would really like to have more
Feedback.
more of the dialogue, more, just because we haven't received anything, and this is not a slight on anybody, but like, just because this is the first time, I really would like to make the change and put it out again to make sure that we're being clear. We've got kind of what the board has said and kind of the ideas that we've heard and the suggestions we've heard today.
Is there any other business that anyone wants to bring in front of the board? In the absence of that, I will move for adjournment. We're good? All in favor?
By
We're-
acclamation, right?
Yep, we are adjourned at 12, call it 12:55, how's that?
That's good. That was a good meeting.
A little off the cuff, but you know.